একটু একটু না
Petition allowed. Review order set aside and pass.
বলে
Yes.
to mention item number 9. I've taken consent from the other side.
Item
What
number-
application? 9 lodging.
9.
9 yes. What application? I've taken consent from the other side. So I pay for the adjournment of difficulty. They pay for on 10.
That of this one.
Oh yes, good. 10. Yes.
Who is Learned Counsel appearing on behalf of
Petitioner, what about?
Mr. S. Burton. September.
Deeply obliged.
Please, Lord. With the consent of other party lordship, I beg to mention item number 6, 7, and 8 lordship. I am for respondent lordship, I had lordship. For 2 weeks lordship. After the list of 2 weeks.
Lordship date may be fixed, Lordship.
Yes, Lord.
16th of September.
After Lord, after 7 weeks.
So we are learned something for the higher part.
After 17 lordship, after 17. Oh, obliged.
May I please, Your Lordship, for the item number 19, may I pray for the adjournment for the
Item number
19?
Nine.
Discussion.
put that place.
Purpa Lamu, Phurpa, P Lamu,
Learned appearing on behalf of
D Das.
the D. Learned Counsel for the respondent number 9. You inform the
Lordship, I am from the petitioner side. Consent has been taken from the
19.
yes.
Leader is the respondent number 9.
Sorry, respondent.
But did you inform the other side?
Yes, Lordship.
Yes.
Consent has been taken from the petitioner side.
What do you want?
Lordship,
When the date can be fixed?
after a week.
After a week. After that. Yes.
May I please? My lord, I beg
Lord.
to mention item number 46, my lord. Well, yes, my lord. Hearing, my lord. My lord, in this case, my lord, the arguing counsel has been eliminated, my lord. My lord, I was late Mr. R. Muzumdar, my lord. He was eliminated in this plans, my lord. My lord, I tried to communicate to the client, but my lord did not communicate, my lord. Kindly
So
assume
the fair being made by Mr.
M. Hussain, my lord.
M. Hussain, learned counsel for the petitioner. You inform the other side?
No, my lord, V. Sharma perhaps no counsel yes, my lord. My lord, V. Sharma reflected in this cost list, my lord.
No, respondents are there. But the name of counsel is reflected. It's B. Sharma,
Yes, sir.
assistant prosecutor.
Yes, sir.
Did you inform?
No, my lord. I have not communicated, my lord.
You first inform. You have to will consider your
Okay, my lord.
first object.
Okay, my lord.
Consent.
Most of them.
Yes.
May I please, Your Lordship, I beg to mention one affidavit in reply to recall from the filing section, my lord. This matter may be tagged with item number 43, my lord. They have filed their IA on 27th.
Item number 43
Yes, to recall.
of today's list.
Yes, my lord. Item 43.
You have filed affidavit in opposition.
Yes, my lord. Routine report. Problem.
Mention urgently, urgently, I need to mention for unlisting the matter which I have filed today. It is regarding my college. Look, I'm just running at 2 o'clock.
Is this petition or
Read petition, Lordship.
senior court? Court number
Lordship,
senior court.
request.
My lord, in this case, my lord, I have to file an amended petition to rectify my lord, some typological error. That petition I have filed today, my lord. So 1 week time, my lord, today itself. I already.
Sir, your name?
M. Hussain, my lord.
Lordship, otherwise,
M. Hussain. M. Hussain.
Lordship, the main writ petition has been disposed of.
Yes,
With
I,
the direction to prefer an appeal before the appropriate authority. Now, whether this IA
Yes.
on a disposal case for vacation is of the stay order.
that will decide court.
If the main petition is disposed of, then
Lordship, it was disposed of on 17 to 2023 itself.
That will decide after
But the
hearing the
petition is
hearing.
directed to prefer an appeal before the
Only I
appropriate
have to
authority.
file my amended petition. Thereafter, court will decide.
that is fine.
My lord, thereafter, court will decide. M. Hussain, my lord.
Then learned application. P. Learned.
Element of which department.
Then learned. After
1 week.
after one as file one interlocutory application.
Yes, my lord.
Oh, amendment of the
My lord, for rectify only, my lord, index, my lord, my only one spelling mistake. That is the last occasion, my lord, the leave was granted.
mistake in the cycle of the IA.
IA.
The matter.
Right.
On behalf of Mr. BJ Ghosh, my lord, matter may be taken away at 2, my lord. The other side is also not. Hello, my lord.
None appears to be. How about your name, right?
Madam, for SCRT on behalf of Mr. Espora,
Miss?
J. Rajkumari.
Oh. Third. Oh. SCR. The number.
Element Education Department, Lord. I'm sorry, Lordship, I am for the respondent number 1, 2, 1 and 2, Lordship. Lordship, Lordship.
In the event of some
Item number 3. Item number 3.
Lordship, let the matter be taken after some time. Mr. Espora is on legs.
May I please your lordship? Lordship, in this case, the petitioner is aggrieved by arbitrary and anomalous appointments of respondent number 10 to 25, my lord. My lord, the relevant advertisement is at page number 32. Kindly come to page number 32, my lord.
all the
Yes, my lord.
Yes.
you have for respondent number.
I have offered all the respondents, my lord. Like not for the private respondent, except for the private for 2, 3, 4, 5, 6, 7, 8, and 9, my lord.
Are you ready to argue the matter?
Yes, my lord. My lord, this matter can be disposed of actually, because a similar matter, my lord, the division bench have directed the APDCL to take steps, and I have already served the copy to him. And that was, he was asked to look into the judgment and to decide whether he to take that route. Because similar judgment, similar issues, only the circle is different. The Honorable Division Bench said that the APDCL is given the duty to issue notice to all the people who have been indebted in the writ petitions and to take call, have a hearing, and they take action, disciplinary action, and if possible. I think that would suffice his issue also.
My lord, the matter may be hard, and then the as prayed by my friend, or such an order may be passed, my lord. But I want to proceed with the facts of the case, my lord.
Okay.
Yes. Thank you. Lordship will kindly come to page number 32.
Yes, Annexer 1.
Annexer 1, my lord. My lord, by this advertisement, applications were invited from intended candidate for filling up of total 1064 posts of Sahayak under APDCL. My lord, somewhere in the middle, kindly find the eligibility of candidates, my lord.
Yes.
As per this advertisement, there were two eligibility categories. Category A was for candidates having ITI certificates, and category B is relevant only, my lord. Category B is reserved for temporary workers engaged in any power utility to work as Sahayak, my lord. And experience, the temporary worker engaged in any power utility for performing the job of Sahayak continuously for more than 3 years. And experience of continuously for more than 3 year engagement is required under the category B, my lord. My lord, there was a vigilance inquiry regarding the allegation of anomalies in the selection and appointment, and the vigilance inquiry was conducted by the Chief Vigilance Officer of APDCL. That vigilance inquiry report was withheld by the chairman of APDCL for more than 2 years, my lord. Lordship will kindly come to page number 129, my lord. My lord, page number 129 is a document obtained by RTI means, my lord. Here, my lord, allow me to read, my lord, the serial number 1 of this document, my lord. The inquiry has been conducted by Sri R.D. Borua, IPS, retired CVO, APDCL, and assisted by various officers and men of APDCL. Inquiry has already been completed and submitted to the chairman APDCL. My lord, the date of this letter is 2nd January 2016. So from this order, this is apparent that, and the inquiry was conducted, and the final report was submitted on or before 2nd January 2016, my lord. But my lord, only after a order dated 13 March 2018 passed in this case, my lord, this report was submitted to the petitioners as well as to this court, my lord. And I have annexed that report as annexer number 19, my lord. Kindly come to next page, my lord. Page number 130.
What?
130, my lord. Next page, my lord.
Yes.
My lord, from this page, the inquiry report starts, and the relevant part is that, my lord, the relevant part is at page number 134. Page number 134, my lord. Somewhere in the middle, starting from the serial number 3. May I read, my lord? The first line is the APDCL authority recommended. Somewhere in the middle, my lord, page number 134. The APDCL authority recommended and selected 28 numbers of departmental trainee Sahayak and posted them in different subdivisions under Ronga Electrical Circle. Subsequently, the deprived candidate alleged complaints against 15 numbers of selected trainee Sahayak as illegal appointment. The vigilance team therefore scrutinized the relevant record and recorded their statement. The gist of the statement are given below. My lord, in this tabular format, the serial number 1, Sanjay Bormon, is respondent number 17, my lord. Serial number 1 is respondent number 17. Kindly see the remarks, my lord, in the table. May I read, my lord? The candidate submitted his application directly to at Rongia Electrical Circle office. Though submission of application come standard form should have routed through proper channel, which was mandatory as per office memorandum. it observed that the application form was signed by the applicant on 26/4/2013. But the official record of receipt was on 18/4/2013. Second, experience certificate issued by Sri MP Sharma, the then SD NESD1 as daily wage worker under contractor of ACB, without specifying the period. On the other hand, Sri so and so that then is AGM Nalbari election division had issued certificates as outsourced daily wage labor with effect from so and so date to so and so date at Nalbari election subdivision 2. He also stated that he issued that certificate on the basis of official record. Sri Sanjay Burman, the candidate, stated that he had worked initially under the contractor of ACB. Subsequently, his service was utilized by the concerned SD at so and so. Experience certificate issued for the period from 1/4/12 to 25/4/13 only, but not continuously for 3 years, which is not as per the procedure. Hence, this appointment found to be violating the laid down procedure, my lord. My lord, in this way, my lord, total 16 candidates are made party in this the writ petition, my lord. Out of them, 15 were found as illegal appointees in this, as per this the CBO report, my lord. Next one is respondent number 12, serial number 2. Mukut Ali at page number 135, my lord. Lordship, I will not read the entire statements. However, the Lordship can quote from here up to page number 150. Anomalies of all the respondents except respondent number 16 are stated in this CBO report, my lord. Then I will lead your Lordship to the final findings of the CBO report at page number 151. Yes. Final findings are at page number 151. Findings, somewhere in the middle, my lord. Findings. The petitioners who have filed petition before Honorable High Court and also before CMD APDCL, the content of their main grievance was that the selection of 15 numbers of Sahayak out of 25 numbers of Sahayak selected and appointed by the APDCL authority for Rongia Electrical Circle APDCL LAR. Rongia was not as per policy formulated by the company. During scrutiny of the various documents pertaining to the selection process, the allegation raised by the petitioners sustained. The vigilance team explained documents plus paper of the said 15 numbers of selected candidates. Since the petitioners have specifically alleged irregularities of appointment of those candidates, the remaining 13 numbers of candidates, their documents, etc., have not come under scrutiny as there is no complaint against them. During scrutiny of the documents papers of the 15 numbers of candidates, see at Flexi, the following irregularities have come to the notice. The application form submitted by almost all these candidates were not routed through proper channel, which was mandatory as per guidelines. Almost all of them have been found to have violated the laid down procedures. Kindly see remarks column of inquiry para 3 from serial number so and so to so and so. In case of few candidates, it is found that they submitted their application form beyond the date of submission of application as specified in the office memorandum placed at Annex 3. The defaulter's name figured at so and so, who is considered to be very serious lapse. Some of the candidates, the experience certificates submitted by the authorized officials of APDCL are found highly irregular, which may kindly be seen at remark column of the inquiry report. In one particular case, the candidate appears to have submitted false experience certificate, which may kindly be seen at so and so. The above analysis clearly indicates the irregularity of the selection process and clear violation of standing orders. The role of the scrutiny committee formed under the direction of CEO is found extremely poor and irresponsible. The above anomalies could have been avoided if the selection committee had performed their duties in the right spirit. one of the important required qualification for the post as directed by so and so order is that the candidate who have serving as a temporary Sahayak for period of 3 years continuously is eligible for the post. But as per norms, no temporary workers is allowed to render his service more than a period of 89 days, and his service is terminated at the end of this end of the said service only, which is very confusing as regards the continuity of the service. Following this principle, there should have been a single candidate temporarily serving as Sahayak in the process. Perhaps this invites some analysis on the matter to avoid confusion in this regard. Then, my lord, the most important part comes. The result sheet signed by the chairman of the selection process bears the signature of the chairman only. There are no signature of other members of the selection committee, which is highly irregular. However, the chairman during course of examination submitted sheets of papers of different result sheets, subcommittees, which may be seen. My lord, the result sheet was also not signed by the members of the selection committee. Only the chairman had signed the result sheet. That is also an anomaly, my lord. My lord, this case may be disposed by giving the direction to the concerned APDCL authorities to consider this vigilance report and take action as per the report after giving a right to hearing to the candidates which job will be affected, my lord. And but however, my lord, in case of respondent number 16, there is no mention in this CBO report. However, from documents obtained by RTI means we have produced some documents which also states that the appointment of respondent number 16 is also bad, my lord. Lordship will kindly come to page number 89, my lord.
By the PPO,
My lord,
by the inquiry officer.
Inquiry officer has not found anything regarding this candidate, my lord. S1 number 16, my lord.
Then
However, my lord, the authorities may be directed to examine his documents and records and to see whether the allegation made in this.
if the civil vigilance officer has already verified his document, where is the question of directing again?
My lord,
Verify his document.
yes, my lord. Kindly, we have obtained some documents from RTI, my lord, which indicates that his appointment is also bad, my lord. As well, please come to page number 18, 89. Page number 89, my lord. Uh, uh, this is a document obtained by. This is a document obtained by RTI means, my lord. Here in this table, serial number 7 is Kusal Boro, who is the respondent number 16 in this case. Here, kindly see the remarks. Works actually in Romia Electrical Subdivision 2 and office of and payment records in daily ways are available with effect from 2011, my lord. My lord, his records are available from the year 2011, my lord. However, as per the advertisement, as per the prescribed guideline, he should have completed more than 3 years at the time of his appointment. So, my lord, the date of advertisement is 9 April 2013. Counting from 2011, he has not completed more than 3 years of experience, my lord. So, my lord, a direction also be given to the APDCL authorities to see that documents of this candidate, my lord, and take a decision, my lord. With such observations as your lordship may deem fit, the first writ petition may be disposed of, my lord, and the second writ petition has slightly different facts, my lord. 2 writ petitions are taken in this file.
Yes, sir.
My lord, the allegations that are there in the CVO, my lord, there is no quarrel to it because it's our CVO. My lord, we were ready to do the investigation and we are ready for doing the conduct of whatever the lordships direct. In fact, my lord, similar kind of exercise had been carried out in different circles which happened in this training. And this matter went up to the division bench. And division bench gave a liberty to and calling all the candidates, scrutinizing all the papers and everything. The issues were same. that the eligibility certificates were submitted at later stage.
However, my lord, vigilance inquiry report was not there in those cases. Otherwise,
Just submit it.
Text or-
Let me submit it here. My lord, at page 15, my lord. The only issue raised in these appeals whether the private respondent satisfy the eligibility criteria as on the last date of submission of application of appointment, the post of Sahayak in the APD cell. It is a contention of the writ appearance that this private respondent did not possess the same. It is now well settled that if any candidate do not possess the requisite qualification on the last date of application or on the date may be fixed by the authorities, any selection or appointment of such person on the public post will be in violation of Article 14 of the Constitution of India. So and so under the at paragraph 4, under 4 circumstances, we direct the respondent APDCL to conduct a verification exercise of all the persons who were appointed to the post of Sahayak, and if it's found that if any of them had submitted his or her requisite essential certificate documents after the last date of submission of application or to the date fixed by the authority concerned or do not submit such certificates, such person may be entitled and their service will be liable to be terminated. However, only after giving notice to them. After completing the exercise of terminating the service of such ineligible candidates by giving due notice to them, the vacant post shall be filled up amongst the remaining other candidates as per the merit, and if any other writ appellant come within the zone of meritorious candidate, they certainly shall accommodate as per the merit of the said vacant post of termination of service as mentioned above. And my lord, by following this, the Honorable High Court, the learned single judge of this court has passed a similar order. So, my lord, there's no dispute or there's no quarrel in the bar that this kind of did happen during the selection of Sahayak, and accordingly there were several writ petitions were filed, and thereafter lots of writ petitions were disposed of on the same grounds. Sada?
Okay.
My lord, it's from the same advertisement, same selection, and same post, only the circle is different. My lord, this was after the division bench judgment. This was on 19th August 2024. There was a division bench judgment was of 24/1/2023. So and so, my lord, here contention of the appellant is at paragraph 6, page 8, my lord. The learned counsel of the petitioners, para 7. The learned, this is of the Cockroach circle, my lord. The learned counsel of the petitioner submit that, except for the petitioner 6 and 7, all the petitioners secured more marks than respondent number 12 to 9. As for the employment advertisement, the B category candidate were required to submit certificate regarding the engagement of 3 years from the concerned assistant general manager. But in the experience of for respondent number 19, the length of experience is shown as 9 months only, for which the said certificate was invalid. It is submitted the last date of application form was so and so. And my lord, there were the anomalies. And at the end, at page 17, my lord, the finding of the learned single judge, at page 16, it starts from paragraph 26. In the terms of the paragraph 4, may I read, my lord? In the terms in the paragraph 4 of the said order dated 24/1/2023, passed by the division bench of this court in writ appeal so and so, this court is inclined to provide that in course of verification conducted in terms of the aforesaid order, if any of the private respondent 8 to 9 are found not to be possessing the requisite 3 years experience or found to have submitted the requisite essential certificate documents after last date of submission of application or date fixed by the authorities concerned, their service would be liable to be terminated as the appointment will serve void ab initio, which shall be done after giving them notice as to why their service of Sahayak should not be terminated. The resultant vacant post should be filled up among the remaining candidates as per the merit and select list, and if any of the petitioner come in the zone of consideration, they shall be accommodated as per the merit and the said vacant post on termination of service mentioned above. Therefore, in the light and the direction contained in order dated so and so, by which this code is bound, this road stands partially allowed to the extent as indicated above. I think, my lord, this judge, both the judgment will suffice the entire, both the cases.
Okay.
Lordship, the second writ petition will be heard separately, my lord. Item number 5. My lord, this case is in this case the same advertisement is related, my lord. However, the facts are different, my lord. Kindly come to page number 13, my lord.
I have some difficulty in item number 24. Actually, I'm late in mention our.
Is it the time of mention?
That's why I'm very sorry. I am
Yes,
late in
sir,
mention.
doing the matter why you are disturbing.
I think one matter is finished. That's why I'm not. Sorry, madam.
Possible, kindly come to page number 13, my lord. This is the same advertisement, my lord. However, here I want to reflect that total 28 numbers of seats were reserved for Rongya Electrical Circle. My lord, from the top, kindly come to the 12 line, my lord. 12 line, Rongya Electrical Circle within bracket 28, my lord. From the top, 12 line, my lord, at page number 13. Rongya Electrical Circle 28.
Yes.
My lord, from this it is indicated that only 28 seats were reserved for the Rongya Electrical Circle, and that fact is also appeared from the CVO report also in the former case, my lord. Now lordship will kindly come to page number 19, my lord. My lord, this was the final, page number 19 is the final merit list of all the selected candidates. It starts from page number 19 and ends at page number 45, my lord. This merit list was published in the month of February 2014, my lord. That is not mentioned, but lordship will kindly note this, my lord. Then lordship will kindly come to page number 49, my lord. 49. Page number 49 is the appointment order, my lord. When all the 28 seats selected candidates name can be found under Rongya Electrical Circle.
46 is the final.
49, my lord. 49.
No. It's 46 is the final selection.
40 page number 19 is the, my lord, merit list. Page number 46 is also the is a selected list of selected 28 numbers of selected candidates, my lord. But this is not the appointment order, my lord. Date of appointment order is relevant actually. Date of appointment order is only relevant, my lord. My lord, at page number 49.
Yes.
Kindly see that the date of the appointment order. This is 4/3/2014, my lord. Here names of the total 28 candidates can be found, my lord. My lord, as per the official guidelines, that is a office memorandum prescribing the norms of selection and appointment, my lord. The merit list is valid for a period of 1 year from the date of recommendation of the chairman, my lord. The office memorandum is at page number 65, my lord. Page number 65, and the relevant office memorandum starts at page number 65, my lord.
Yes.
And a relevant part of the memorandum is at page number 69, my lord. Please come to page number 69. In the page number 69, lordship will kindly find preparation of merit list. The heading, preparation of merit list, somewhere in the middle. Preparation of merit list.
Yes.
May I read, my lord? The selection committee shall prepare one combined merit list with candidates from both categories on the basis of marks obtained, containing the names of selected candidates equal to the number of vacancies to be filled up in order of merit, keeping the reservation policies as per 100 point roster, and forward it to the appointing authority. Thus, chairman and managing directors shall be accepting the authority of the recommendation of the selection committee. The merit list shall remain valid for a period of 1 year from the date of approval by the chairman or managing director, my lord. My lord, here this particular line is important. My lord, this indicates that the merit list is valid for a period of 1 year, my lord. And Lordship had seen the appointment order dated 4 March 2014. My lord, it indicates that the merit list shall be valid for a period of 1 year from 4 March 2014.
Yeah.
Even after, however, my lord, even after expiry of the final merit list, my lord, several candidates were selected and appointment without any interview and first interview and selection, my lord. From the earlier,
Are you sure that in the meantime, this was not extended?
no, my lord. My learned friend can confirm that, my lord.
My lord, this petition does not have any merit. First of all, my lord, his prayer is only that his representation should be considered. I don't understand what link he has to this entire writ petition, or what right he has to challenge this, because he's not a selected candidate, nor his name is a zone of consideration. His only prayer is that my representation should be considered. This appointment has been made. Neither he has shown any documents in the entire writ petition that those matters were not pending before the court. Only prayer is that his representation should be considered. As a exercising his right of a fundamental, his representation has to be considered, that we can consider and we can pass an order. But other than that, my lord, there is nothing to be examined here, my lord.
My lord, let me finish my part, and Lordship will decide what action may be taken here. Lordship, kindly come to page number 60 next, my lord. Page number 60. Only I will take only few minutes, my lord, to end this case matter.
69.
60, my lord. Page number 60. Kindly come to page number 60. My lord, page number 60 is a appointment order issued on 20th July 2015, my lord. Here, from the same merit list, total 16 numbers of candidates were selected. Kindly see the date of the order, 20th July 2015, my lord. It indicates that it was issued after expiry of the final merit list, my lord. This is the first order. And second order is at page number 62, my lord. Page number 62. Subsequently, my lord, page number 62 is a subsequent order which was issued on 10 July 2015. Here again, my lord, 4 number of candidates were selected from the same examination, my lord. Next page is my lord, page number 63, my lord. Page number 63, my lord. Date of this order is 1 September 2015, my lord. Again, here 2 number of candidates were selected from the same examination, my lord, even after expiry of the final merit list, my lord. My lord, if I make, I was also a candidate of this selection and interview, my lord. If I make all this the candidates party to the case, the procedure will be lengthy, my lord. Therefore, I just submitted a representation to the chairman of APDCL to take action against those illegal appointees and set aside the appointments, my lord. And that representation was not considered and disposed of, my lord. So Lordship may dispose of this case by giving a direction to the respondent authorities to consider this application. And if after considering this application and after giving right to hearing to all those selected candidates, if any anomaly is found, if allegations made in this writ petition are found to be correct, then their appointments may be set aside, my lord. By giving that simple order, this petition may be disposed of, my lord.
My lord, may I just submit in this in the second petition, my lord. My lord, first of all, he does not have any locus standi because it does not even come to the zone of considerations. And my lord, there is no,
Whether he had filed any application.
he has filed a representation. His even
Any application.
Yes, my lord, there is an application which is pending, which is in my office file also. Original record is there. There is no dispute to it. This is the original file from your court. So, my lord, the consideration of representation can be allowed because it is says in his prayer that is therefore prayed. It is highly expected that your applicant, that the whole matter of alleged anomalies in the aforesaid appointment to the post of Sahayak is truly and properly investigated as per the aforesaid direction of the former Bijuli Bhavan. The fact of alleged ineligibility of many candidates and other irregularities in the aforesaid selection would be found. He is talking about the CVC report. It is therefore respectfully prayed that your good self would be pleased to take appropriate steps so that the aforesaid selected candidates who are at present being engaged for a period of 1 year should not permanently be appointed as Sahaya before completion of the aforesaid vigilance inquiry for the end of justice. This was the letter that they have submitted. And my lord, so only consideration that his right of representation can be considered because that's his, that he has a right, legal right based upon it. Rather than that, my lord, he does not have any locus standi challenging because he has only ground is that you have made appointment after the selection list, after the selection. But what does the language say so? The language says so is this, my lord, of the office memorandum. At B, my lord, at the appointing authority after the preparation of merit list, the selection committee shall prepare one combined merit list with candidates from both the categories on the basis of the marks obtained, so and so. The chairman and the managing director shall be accepting the authority of recommendation of selection committee. The merit list shall remain valid for a period of 1 year from the date of approval by the chairman and managing director. The appointing authority and obtaining approval of the chairman and managing director shall make appointment from the merit list following the reservation policies. Second, the company board taking into the account backlog in any subject to the verification of character, antecedent, and medical fitness report. So there was a liberty also was given to the APDCL as for the OM that you have the liberty if you want you can extend. So that he has not, there is nothing on record to show that has not been done. So that can be verified by representation and an order will be passed, my lord.
Or you tell me whether there was any exception.
My lord, that record I don't have as of now in the office file. There is not there. So the reconsideration of representation and then order would an order would be passed and that would entitle them because his only prayer is to consider representation. So let the representation be considered and let
All the relief claimed by the victim.
I understand, but I don't have that, my lord. As for the office file, this document is not there. So it will be not correct in my part to something which is not there, my lord. But it's not this.
Verbal inspection of the after
My lord. My lord, I'll just obtain a verbal instruction, my lord.
In which part of this memorandum and liberty is given to the chairman to accept the
My lord, it is at the writ petition, my lord, at second line, my lord. The appointing authority on obtaining approval at page 69, my lord.
Yeah.
On obtaining approval of the chairman and managing director, shall make appointment from the following merit list following a reservation policy. After a period of 1 year.
However, the seats cannot be extended. Only
No,
28.
seats are not extended.
These are additional appointments after filling up of 28 number of seats, my lord.
These are not additional appointments. My lord, the only.
Already 28 were selected, my lord. Then through the back door, they have appointed another several persons by issuing those orders, my lord.
My lord,
They cannot increase the post, my lord. As 28 seats were earmarked, they have to fulfill the 28 seats only, my lord. If there are fresh seats available, then they shall publish an advertisement, my lord.
Yes, that is true, my lord. My lord, what I'm suggesting here, my lord.
You tell me whether this office memorandum has given the authority to the chairman.
Yes, my lord.
Extend the select list beyond 1 year.
Yes, that was that I'll find out, madam, whether this was approved. It was whether there was a recommendation or not, whether there was an extension of it or not. If it was not there, my lord, I'll just let me give a verbal instruction on it.
You represents for before 2 p.m.
My lord.
Yes, my lord. Can we take at 2 p.m., my lord? Later.
No, before
Not
two.
this the matter again. Not take up the court factor.
Yes, my lord. Highly obliged. Respondent number one.
Wait, listen. This matter, my lord, it was initially heard by learned, my lord, Honorable Mr. Justice Jamir, my lord. It was kept part heard and was kept in CAV. But unfortunately, before the judgment 12/9/2024, there's an order which says that the matter was kept as CAV. But my lord, unfortunately, my lord, before he could deliver the judgment, he had to, my lord, go to a different high court. May I just indicate the facts in brief, my lord? On 17/4/2012, my lord, there was an advertisement, which my lord will find at page 18, my lord. Page number 18. And my lord, the post in question is at serial number 5, lower division assistant, my lord. LDA, my lord. Page number 18, my lord. Lord, in this advertisement, my lord, I participated, my lord, and I came out successful. And they gave me an appointment letter, my lord, which my lord will find at page 23, my lord. Page 23. It's an order dated 21/2016. And may I just read out page 23? With reference to their applications for the post of LDA and as per the recommendations of the selection committee in its meeting held on 4/1/2016 and subsequent approval of the Honorable Vice Chancellor on 5/1/2016, following candidates are engaged as LDA in the offices placed as shown against their name as given below. And my name is at serial number 3, my lord, Sosanko Soikia. Place of engagement, Secretary Office, my lord. Now, if your lordship kindly turns to the next page, page 24, your lordship will kindly see serial number 5, my lord. Page 24. Serial number 5, my lord. It says, the engaged candidate shall have to follow the service conduct rules applicable for university employees. So, my lord, the service rules which applies is, my lord, that Guwahati University, my lord, service rules, 1970. So this is, my lord, specifically mentioned in the appointment letter at page 24, my lord, serial number 5 itself, my lord. Well, pursuant to my appointment, my lord, my services was extended from time to time, my lord. I was initially only a temporary employee. Now, since, my lord, my services were not regularized, me and some similarly situated person, my lord, we approached this honorable court, praying for regularization, my lord. We filed a writ petition. That writ petition is, my lord, WPC number 4271 of 2018. And, my lord, on 25/7/2023, my lord, the writ petition was allowed.
WPC number?
WPC number, my lord, 4271 of 2018, my lord. That order I have annexed, my lord, at page number 92, running page, my lord. Page number 92, my lord.
Yes.
My lord, page number 92, my lord, will see, my lord, WPC number 4271 of 2018, my lord. And serial number 3, my name, your lordship will find Sosanko Soikia. And my lord will come to the relevant portion of the judgment at page number 104, my lord. Page 104. Paragraph 19, my lord.
Yes.
For the reasons stated herein above, this court is of the opinion that all the writ petitions must succeed and are hereby allowed. The writ petitions are therefore disposed of with a direction upon the respondents, more particularly the Registrar of Guwahati University, to process the cases of the petitioner in light of the observations made herein above, and and thereafter take necessary steps for regular absorption and or regularization of services of all the petitioners by issuing necessary office orders, my lord. So, my lord, this honorable court regularized my services. Now, in the meantime, my lord, on 25/9/2021, the petitioner was arrested with regard to a, my lord, criminal case, which is vigilance PS case number 4 of 2021. I was arrested on 25/9/2021, my lord.
After the order being passed by this court, your service was regular.
It was, my lord, that case was subsequently going on before this honorable court. Initially, I was appointed, my lord, and we filed a writ petition. And on 25/7/2023, your lordship allowed the prayer in the writ petition, my lord. Now, in the meantime, what had happened on 25/9/2021, I was arrested, my lord. That is prior to the judgment. 25/9/2021. With regard to vigilance PS case number 4 of 2021. I was arrested.
Case number, vigilance case number.
PS case number, my lord, 4 of 2021. Vigilance PS case number 4 of 2021.
Yes.
I was arrested. Now, the day I was arrested, my lord, was the day they terminated me from service. That impugn order, my lord, will find at page 38. Page number 38, my lord. This is the impugn order of termination. May I just read out? Page 38.
Yes.
This is notified for information of all concerned that the Chief Minister's Special Vigilance Cell has arrested number 1 Sri Sosanko Soikia, number 2 some other persons in connection with the APDCL recruitment test. In view of the above, that means in view of my arrest, the service of Sri Sosanko Soikia LDA has been terminated with immediate effect as per clause 1 of the terms and conditions of his appointment order dated 21/2016. And my lord will see at the bottom, second last paragraph, it says, moreover, the entry of the above 3 person is restricted inside the Guwahati University henceforth. So, my lord, they not only terminate me, and if your lordship kindly turns to the next page, page number 39, your lordship will see copy for information and necessary action 2, 1, 2, 3, 4, 5, 6. They have given copies to everybody, but they have not given a copy to me. They don't serve a copy to me. So, my lord will see on 25.
Yes.
So, my lord will see on 25/9/2021, I have been arrested. My appointment letter says that the Guwahati service rules, university service rules have to be followed. Now, without even, my lord, adhering to the procedure laid down in the rules, they terminate me with immediate effect, and they don't stop there, my lord. They go on to the extent of stating that even my entry into Guwahati University is barred. So, my lord, page 38, the impugn order of termination is an ex officio stigmatic order, as it appears from a bare perusal. Now, my lord, they don't communicate me this order. So, what I do, my lord, they don't communicate me this order. So, I file RTI.
Yeah.
So what I do, my lord, they don't communicate me this order. I file RTI. They do not give me a reply. Somehow after running to from pillar to post, my lord, I obtain this page 38 somehow. And I come before your lordship. I challenge this order before your lordship. And my lord will kindly find that order, the first order in my lord, page order dated 36/2022. Honorable Justice A.M. Bujor Barua, 36/2022, and paragraph 10, my lord will see. Paragraph 10, my lord. They say, considering the aforesaid three reasons on a prima facie case being made out, the balance of convenience as well as irreparable loss that the petitioner may suffer, in the interim, it is provided that the notification dated 25/9/2021 terminating the petitioner from his engagement shall remain stayed until further orders. So this honorable court had stayed this impugn order dated 25/9/2021 on the first day itself, that is on 36/2022. So as on date, my lord, this impugn termination order is stayed. Now, my lord,
Yes.
after we file the writ petition, the government files their affidavit. And they take a very bizarre stand, the Guwahati University, the respondents, and they take a very bizarre stand, my lord, at page 14, that is, my lord, running page 57. This is the first affidavit filed by the government, by the Guwahati University, page 57 from the respondents. Paragraph second paragraph, my lord. Internal page 14, my lord, and running page 57.
Yeah.
Second paragraph. So this is the first stand of the respondents, state respondents. As such, the matter has become infructuous and of academic interest only. The writ petitioner, having been out of service long back without any discernible as well as conscious effort to move against the said termination order in any forum, including this honorable court, during the relevant period and view of the instant factual and legal metrics, it is humbly stated that this honorable court may not like to issue a futile writ exercising power under Article 226 of the Constitution of India in the instant case. So, my lord, the understanding of the state respondents at the time of filing the first affidavit was that this matter is infructuous for whatsoever reasons. So that was their understanding of the matter. Although it is a very bizarre stand, but that was the stand nonetheless. So this was the first affidavit. Then, my lord, on 27/2/2024-23, the hearing of this writ petition commenced. My lord will find that order at page 124. Page 124, my lord, running page. So hearing of this matter commenced, my lord. So this is an order dated 27/2/2004. It was heard in part. And on the next date, my lord, records were directed to be produced. Now, my lord, during the course of the hearing, my lord, once they realized that this first stand of the state respondents are not sustainable in law, they tried to they took a complete U-turn. Now, what they did, the second affidavit, my lord, will see at page, my lord, 109. At page 109, they basically say, at page 109, the last paragraph, they said, they took a complete U-turn and they say that departmental inquiry in the present case has been dispensed with. They say it has been dispensed with. Now, in the first affidavit, my lord, the first affidavit was filed on 28/7/2022. That was the first affidavit of the state respondent. And in that affidavit, my lord, it contains 27 pages. The first affidavit, which was filed on the behalf of the government, that is, my lord, on 28/7/2022, which starts at page 44 and ends at page, my lord, 70. The first affidavit filed by the state respondents, it starts at page 44 and it ends at page 70. Page 44 it starts and page 70 it ends. The first affidavit. So in the first affidavit, my lord, in those 27 pages, there is not a single whisper that the inquiry against me was dispensed with. So that is a fresh ground, my lord, the state respondents have manufactured during the course of the hearing. So this is the factual background, my lord, before your lordship. And with regard to the same, my lord, I would like to place some case laws for your lordship's kind perusal. কেসগুলোর বাঞ্চেটা আছে আমার সিরিয়াল করা আছে হাইলাইট হবে there's a bunch of case laws, my lord. We have made it serially, we have arranged it for your lordship's kind perusal. So this is the factual background, my lord. First is, my lord, Purushottam Lal Dhingra. That is the first case law, my lord. My lord. Dada.
Yes.
My lord. But before I take your lordships to the Purushottam Lal Dhingra, my lord, may I just indicate Article 311(2). Article 311(2), my lord. If your lordship kindly has a look, may I just read out?
Yes.
It says, my lord, no such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. But basically it says, before, my lord, inflicting an punishment upon somebody, there has to be an inquiry, and in that inquiry, that person has to be, my lord, informed of the charges against him. What are the allegations? Why is he sought to be terminated? At least an opportunity of hearing has to be given. That is what 311(2) says, which was admittedly not done in the facts of the present case. In the present case, my lord, I was arrested on 25/9/2021, and on the same day itself, I was terminated. No show cause, no DP, no evidence, no examination, no cross-examination of witness, nothing, my lord. Now, my lord, 311(2) is applicable even for temporary workers. And that is what Purushottam Lal Dhingra had laid down. If a lordship kindly looks at paragraph 2 for a moment, my lord, Purushottam Lal Dhingra. May I just read out? Paragraph 2, my lord. The facts are shortly as follows.
Yes.
Paragraph 2, my lord. The facts are shortly as follows. In August 1924, the appellant joined the railway engineer as a signaller telegraphist. As a result of the selection, he was promoted as section controller in 1942 and as deputy chief controller in 1947, as the chief controller in 1950. Now, all these posts were in class 3 service. On March 31, 1951, 7 candidates, including the appellant, appeared before the selection board, constituted for being a candidate for the post of assistant superintendent railway telegraphs, which was a gazetted post in class 2 office cadre. The petitioner was selected out of the 7 candidates for this post. On July 2, 1951, a notice of appointment was issued from the headquarters of the East Punjab Railway, Delhi, notifying that Mr. Purushottam Lal is appointed to officiate in class 2 service as assistant superintendent railway telegraphs headquarters office vice Mr. Sahuram, whose term of temporary re-employment expires on the afternoon of 3rd July 1951. The applicant actually relieved Mr. Sahuram in the afternoon of so and so. It appears that on April 28, 1953, one Gauri Shankar made certain adverse remarks against the appellant in the confidential report. Now, certain adverse remarks were made, and this is what this honorable court had to say, my lord. If your lordship kindly turns to paragraph 9. Or I'll take your lordship directly to the operative portion, my lord. Paragraph 37 at internal page 17. Paragraph 37. I'll just point out the relevant portion, my lord. I'll not trouble your lordship with the entire paragraph. Paragraph 37, my lord.
Yes.
The position may therefore be summed up as follows. Any and every termination of service is not a dismissal, removal, or reduction in rank. A termination of service brought about by the exercise of a contractual right is not per se dismissal or removal, as has been held by this honorable court in Satish Chandra versus Union of India. Likewise, the termination of service by compulsory retirement in terms of a specific rule regulating the conditions of service is not tantamount to the infliction of punishment and does not affect Article 311(2). In either of the above mentioned cases, the termination of the service did not carry with it penal consequences of loss of pay or allowances under Rule 52 of the fundamental rules. It is true that misconduct, negligence, inefficiency, or other disqualification may be the motive or the inducing factor which influences the government to take decision or action under the terms of the contract of employment or service rules. Nevertheless, if a right exists under the contract or the rules to terminate the service, the motive operating on the mind of the government has been said in Srinivas versus Union wholly irrelevant. Now, this is very important, my lord. In short, if the termination of service is founded on the right flowing from the contract or the service rules, then prima facie the termination is not a punishment and carries with it no evil consequences, and so Article 311(2) is not attracted. But even if the government has by contract or under the rules the right to terminate the employment without going through the procedure prescribed for inflicting the punishment or of dismissal or removal or reduction in rank, the government may nevertheless choose to punish the servant. And this is very important, my lord, if the termination of service is sought to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is a punishment and the requirements of Article 311(2) must be complied with. So therefore, my lord, if in the instant case, my arrest was the primary consideration of my termination order. The day I was arrested, immediately they gave me a termination order. And there is my lord, such a stigma attached to the termination order that I am not even allowed entry into the Guwahati University, my lord. That is the amount of stigma that impune termination order is laden with. And therefore, my lord, the protectional safeguard under Article 311(2) could not have been dispensed with, my lord. At least I should have been given an opportunity of hearing, my lord. They should have heard me. At least a show cause notice, my lord. And thereafter, my lord, as already stated, if the servant has a right to continue in the post, then unless the contract of the employment or the rules provide to the contrary, his services cannot be terminated otherwise than for misconduct, negligence, inefficiency, or other good and sufficient grounds. A termination, this is very important, my lord, this line. A termination of the service of such a servant on such grounds must be a punishment, and therefore a dismissal or removal within Article 311, for it operates as a forfeiture of his rights, and he is visited with the evil consequences of loss and allowances. It puts an inedible stigma on the officer affecting his future career. In my case also, my lord, this termination order, it puts a stigma, lifelong stigma upon me for my whole life. And if your lordship kindly turns to the next page, the bottom paragraph 37 at the bottom, in the middle, my lord, the line starting from the use of expression terminate or discharge is not conclusive.
Yes.
The use of expression terminate or discharge is not conclusive. In spite of use of such innocuous expressions, the court has to apply two tests mentioned above, namely, number one, whether the servant had the right to the post or rank, or number two, whether he has been visited with evil consequences of the kind herein referred to above. If the case satisfies either of the two tests, then it must be held that the servant has been punished and the termination of his service must be taken as a dismissal or removal from service, or the reversion to his substantive rank must be disregarded as a reduction in rank. And if the requirements of the rules under Article 311, which give protection to the government servant, must have been complied with, the termination of the service or the reduction must be held to be wrongful and in violation of the constitutional right of the servant. My lord, in my humble submission, my lord, in the present case, I satisfy both the two tests. Number one, whether I had my lord, right to the post, which I had. I had, my lord, selected my appointment through a valid selection process. And I'm sorry. So in the instant case, my lord, what I was trying to impress upon your lordship was, number one, my lord, I fulfill both the tests. Number one, whether this servant had a right to the post. Yes, I had a right. I had secured my employment through a valid selection process. And number two, whether I have been visited with evil consequences. Yes, my lord. They don't even allow me entry in the Guwahati University, my lord. It cannot get more evil than this. And therefore, the requirements of Article 311(2), my lord, could not have been dispensed with. And my lord, secondly, my lord, Majid Ansari, Majid Ansari, my lord. Printout is there, my lord. Majid Ansari. I'll only point out the relevant paragraph. Paragraph 12, my lord. Paragraph 12.
So forward, this is the judgment of this court.
My lord,
If the proposition of law is settled by Supreme Court, why is it necessary?
necessary. My lord, this can be skipped, my lord. It's basically Majid Ansari is, my lord, that Purushottam Lal Dhingra has been applied in our Guwahati High Court also. We follow that. That is the only reason why I wanted to, my lord, bring out. Majid Ansari, you can skip, my lord.
Yes.
Third is, my lord, DM Beliappa, my lord.
Any other point?
For the other point, my lord, DM Beliappa. Now, DM Beliappa at paragraph 18. DM Beliappa at paragraph 18, my lord. May I just read out, my lord? That the manager government bench press versus DM Beliappa.
Yes.
DM Beliappa, my lord. Paragraph 18, my lord. But just on a different point. Paragraph 18. Mr. Birappa's first contention is that Articles 14 and 61 Constitution have no application whatsoever to the case of temporary employee whose service is terminated in accordance with terms and conditions, because the tenure or duration of the employment of such an employee is extremely precarious and dependent upon the pleasure and decision of the employer state. In our opinion, no generalization can be made. The protection of Articles 14 and 16(1)(a) will be available even to such a temporary government servant if he has been arbitrarily discriminated against and singled out for harsh treatment in preference of others. So basically, my lord, that Article 14 and Article 16 is available even to temporary employees, and that is the only reason why, my lord, I wanted to place DM Beliappa before your lordship. DM Beliappa. And next is Sujata Nath. Basically 2019 5 GLT 774. Your lordship can skip that because that DM Beliappa's principle has been applied in our local high court also. Paragraph 11 and 12. Just for that purpose, I think it is not required to be repeated, my lord.
Right.
Sujata Nath, my lord, versus State of Assam and others, my lord.
Right.
Or next is, my lord, Pavendra Narayan, my lord. Paragraph 29. Paragraph 29, it defines stigma. May I just read out, my lord? Pavendra Narayan paragraph 29, my lord, it says, before considering the facts of the case before us, one further seemingly intractable area relating to the first stage need to be cleared. That is, what language in a termination order would amount to stigma? Generally speaking, when a probationer's appointment is terminated, it means that the probationer is unfit for the job, whether by the reason of misconduct or inaptitude, whatever the language used in the termination order may be. Although, strictly speaking, the stigma is implicit in the termination, a simple termination is not stigmatic. A termination order which explicitly states what is implicit in every order of termination of a probationer's appointment, it is also not stigmatic. The decision cited by the parties and noted by us earlier also don't hold so. In order to amount to a stigma, the order must be in a language which imputes something over and above the mere unsuitability of the job. So basically, my lord, if it is a termination simpliciter, if they simply terminate me, then, my lord, following the principles of natural justice are not required. But when they have issued a termination order with such stigmatic remarks, to the extent that my entry into the university itself is barred, in that case, my lord, the principles of natural justice will have to be, my lord, followed, in my humble submission. This order is in and out stigmatic. The termination order dated, my lord, 25/9/2021. Now, my lord, my next reliance So, my lord, the purpose of showing all these judgments from Purushottam Lal Dhingra, D.M. Beliappa, and my lord Pavendra Narayan was to impress upon your lordship that in the present case, the moment I was arrested was the moment I was terminated without following the procedure under Article 311(2), and therefore, my lord, the Articles 14, 16, and 311, 21, and 311(2) have been flagrantly violated in the facts of the present case. Now, my lord, next judgment is Mohinder Singh Gill, paragraph 8, my lord. Paragraph 8.
Regarding the affidavit.
Affidavit. My lord, they cannot supplement the reasons in the impugned termination order by way of a fresh affidavit.
But after this judgment, several other judgments are there,
There.
where it is stated that it can be.
But, my lord, in essence, Mohinder Singh Gill has not been diluted. All it says that the termination order, if we allow the authorities to supplement the reasons by way of fresh affidavit, there will be no end to it, my lord. They can come with fresh grounds. As on that, Mohinder Singh Gill is not overruled, my lord.
Okay.
Because in the first affidavit, they had taken one stand. The first affidavit contained 27 pages, not a whisper. Now, my lord, suppose now they want to say what they want to say, my lord, just for one. They want to say that if your lordship kindly takes up the, my lord, Article 311 for one moment, 311(2), what they want to say during the course of the inquiry, they have come up with a new plea after filing the second affidavit that the inquiry has been dispensed with. There was no requirement of holding an inquiry because it was not practicable to hold an inquiry. If your lordship kindly takes, my lord, 311(2) for one moment, that exception which says, if your lordship kindly sees, my lord, just one thing I would like to place. 311(2) I've already read out. Now the exception provided further that this clause shall not apply, clause B, where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry. So they want to say that 311(2) will not applicable because it is not reasonably practicable to hold an inquiry against me. And those reasons, what are those reasons that your lordship will find at the, my lord, the second affidavit? kindly take up the second affidavit which was filed by the government, my lord. Page 106, it starts. It starts at 106. And 109, they have quoted that reasons. Page 109. Now, this is the 109, my lord, the last paragraph. May I just read out, my lord? It says, in such situations, it is required that by employee who happens to be engaged by Guwahati University be immediately suspended, and charge sheet is to be served upon him to start the disciplinary proceeding. Normally, that is what they do, my lord. When somebody is arrested, my lord, they are deemed to be suspended once they spend more than 24 hours in custody. However, this is not feasible to be done as he is presently under police custody, and relevant records to be verified for the purpose of disciplinary proceeding could not be accessible for the university. Further, it is clear that the said DP will be lengthy and time consuming, given the voluminous documents to be checked, while his engagement is valid only till up to 31/12/2021. Under these circumstances and given situation, it is well nigh impossible or not feasible to start an departmental inquiry against the Sasanko Soikia in form of a DP. So these are the reasons which have been allotted, freshly sought to be incorporated for not holding a DP. Just because it is voluminous documents will have to be checked, will they not conduct a DP, my lord? That is the question I would like to pose to myself. Page number 109, the last paragraph.
Yes.
Now, my lord, the first reason is the petitioner is in police custody, and therefore it is not feasible to conduct the department proceeding. Now, if your lordship kindly takes up the rules, the Guwahati University rules, that rules ekdom mast hote. Rule 26. Now, my lord, the first reason which has been sought to be given on behalf of the state respondents is that the petitioner was in police custody, and therefore it was not feasible to conduct a department proceeding. Now, if your lordship seeks rule 26 of the Guwahati University rules, then there is a power of suspension. So rule 26 provides for suspension. If they want, my lord, all they could have done was to suspend me and initiated the DPI after I was released from detention. That is the normal procedure. So the first reason which has been put forward by the government, by the state respondents, is absolutely irrational, my lord, and absolutely arbitrary, in my humble submission. That is the first reason, my lord. Justification for. They've basically given three reasons in page 109 and 110. And this is the first reason. First reason is that petitioner is in police custody. They should have put me under suspension. And once I'm released. And my lord, second reason which they've given is that records cannot be, if your lordship sees, they say, first, second, third, fourth, fifth, sixth line, my lord, page 109, sixth line. Page 109, sixth line, in the bottom, my lord. And the relevant records to be verified for the purpose of disciplinary proceeding could not be accessible by the university. If that is with the chief minister's, my lord, vigilance or with whomever it was, because the records were not with me. The records were always with the Guwahati University. And if it all was in before a different department, they could have requisitioned the records. So even the second, my lord, justification which has been sought to be given, even that is perverse on the face of the records. And my lord, thirdly, my lord, they say the DP will be lengthy and time consuming. Now kindly come, my lord, to page number 40, my lord, rule 48 of the Guwahati University rules, my lord. Page number 48. They say it will be time consuming. Given the voluminous documents to be checked. The last line in page 109, my lord. They say the second last line, page 109, my lord. My lord, rule is, my lord, rule 48. Rule 48, my lord. Rule 48. Now, the penalty which was imposed upon me, my lord, that was under Rule 46. This Rule 46(8), dismissal from service, internal page 23. So that was the extreme, my lord, the major penalty was imposed, and the procedure is at page 24, internal page 24, the procedure. So the procedure says, my lord, initially they'll have to give they have to frame definite charges. They have to give me a statement of allegation, statement of imputation. I'll submit my written statement, and then there'll be examination, cross-examination. The documents will have to be proved. So that's the procedure. Just because it is time consuming, just because to check the records it will be time consuming, doesn't mean they can dispense with the inquiry, my lord. When they're putting such stigma upon me, they don't even allow me to enter the Guwahati University, my lord. Just because it is voluminous, just because the authorities will have to check and verify, just to shirk from their responsibility, they cannot immediately, my lord. No, my lord, why I was pointing out these three grounds is because the Honorable Apex Court, as well as this Honorable Court, had said, in fact, if your lordship kindly takes Jaswant Singh, my lord, Jaswant Singh is there. Paragraph 8. I'll not trouble your lordship with the entire judgment. I'll only point out the relevant paragraph, my lord. Paragraph 8, my lord.
Yes.
May I just read out, my lord? Paragraph 8. This is, in fact, I'll directly take your lordship to relevant line. 1, 2, 3, 4, 5. Sixth line, my lord. Paragraph 8, sixth line from the top. The line starting from it was incumbent.
Yes.
It was incumbent on the respondents to disclose to the court the material in existence at the date of passing of the impugn order in support of the subjective satisfaction recorded by the respondent number 3 in the impugn order. Clause B of the second proviso to Article 311(2) can be invoked only when the authority is satisfied from the material placed before him that it is not reasonably practicable to hold a departmental inquiry. This is clear from the following observation at page 270 of Tulsi Ram's case. Now that Tulsi Ram's case has been read out. A disciplinary authority is not expected to dispense with the disciplinary authority lightly or arbitrarily, or out of ulterior motives, or merely in order to avoid the holding of an inquiry, or because the department's case against the government servant is weak weak and must fail. Just because the government case is weak, they cannot dispense with the inquiry lightly or arbitrarily, my lord. The decision at the last paragraph, the decision to dispense with the departmental inquiry cannot therefore be rested solely on the ipse dixit of the concerned authority. When the satisfaction of the concerned authority is questioned in a court of law, it is incumbent upon those who support them to show that the satisfaction is based on certain objective facts and is not the outcome of the whim or caprice of the concerned officer. Now, my lord, may I just pause here for a moment, my lord? So, the authorities have to arrive at a satisfaction that the reasons on the basis of which they are dispensing with the inquiry has to be objective. Now, the reasons which have been given at paragraph, my lord, 109, that the documents will have to be checked, it will be voluminous, it will be lengthy, time consuming. Those are not objective facts, my lord. Those are not cogent reasons. There has to be a good ground, and in view of that, my lord, the appeal the petitioner was granted relief in this case of Jaswant Singh. Basically, Jaswant Singh came from my lord Tulsiram. And second matter, my lord, second, if your lordship kindly takes, the law has also evolved over a period of time with regard to dispensing of an inquiry under 311(2). Now, the next case law, my lord, Southern Railway Officers Association, my lord, 2009 9 SCC, page number 24. Southern Railway Officers Association.
Yeah.
Paragraph 21, my lord. Paragraph 21.
Yes.
My lord, it says, indisputably, holding of an inquiry if any misconduct is alleged on the part of delinquent official is obligatory when the delinquent employee is to be informed of the charges against him and given a reasonably opportunity of being heard in respect thereof. The second proviso appended thereto, however, makes 3 exceptions in regard to the constitutional requirements to hold an inquiry. Clause B whereof provides that in a case where the disciplinary authority is satisfied that it is not reasonably practicable to hold such inquiry, subject of course of the condition that therefore reasons are to be recorded in writing. Recording of reasons thus provides adequate protection and safeguard of the employee concerned. It is now well settled that the reasons so recorded must be cogent and sufficient. Satisfaction is to be arrived by the disciplinary authority for the aforementioned purpose cannot be arbitrary, it must be based on objectivity. Basically, my lord, what a reasonable person would have done at that particular point of time. And the reasons which have been recorded in the affidavit, second affidavit, that it will be time consuming, the voluminous, the documents will have to be checked. These are not cogent reasons, my lord, and these are not adequate reasons. That is my humble submission. And my lord, the next
Regime of the five.
will come. My lord, I had already indicated, my lord, Jaswant Singh and Southern Railway, which says that the reasons has to be cogent and relevant. And thereafter, my lord, law has slowly evolved. Then came Reena Rani, 2012 10 SCC 215, my lord. Reena Rani, my lord, versus State of Haryana. I will directly take your lordship to the main point, my lord.
Yes.
My lord, if your lordship kindly turns to paragraph 8, my lord. Paragraph 8, Reena Rani. May I just read out, my lord? In the order of dismissal, the superintendent of police had not disclosed any reason as to why it was not reasonably practicable to hold regular departmental inquiry. The learned additional advocate general fairly stated that the order of dismissal does not contain the reasons as to why it was not reasonably practicable to hold the regular departmental inquiry against the discipline. Even in my case, my lord, your lordship has seen in the termination order, they have not stated anywhere that the inquiry has been dispensed with, and on one reasons. It is only later after filing of the writ petition, my lord, during the course of the hearing, they have taken a fresh ground. And if your lordship kindly turns to the, I'll just take your lordship to the main point, paragraph 11. Internal page 5, my lord. Internal page 5, paragraph 11.
Yes.
It says, in Jaswant Singh versus State of Punjab, the two judgments referred to the ratio of Tulsiram. Already referred. Only thing that it has been reiterated, and only last 3 case laws of our Guwahati High Court. If your lordship kindly takes Ruben Kolita for a moment, my lord. Guwahati Local High Court, paragraph 17, just one paragraph.
What is there?
It says, paragraph 17 says, my lord, Honorable Justice, Mr. Justice Suman Shyam, it says, coming to the facts of the case as noted herein above, the reasons as to why disciplinary authority had felt that it was not practicable to hold an inquiry against the petitioner have been recorded in the impugn order, and the same has been discussed herein above. Applying the ratio of the decisions referred to above, these decisions, it says, This court is of the opinion that the reasons recorded were neither adequate nor relevant. So the reasons will have to be adequate, relevant, and so.
Miller. Lord, my learned friend has not placed the facts properly, Lord. Some facts, omitted. So, Lord, I take your lordship to my affidavit, Lord, to paragraph 5, Lord. First facts, Lord, then, Lord, the law, Lord. The authority, Lord, I will place, Lord, one by one. My affidavit in opposition. It starts from page.
First one or second one?
First one. Lord.
Okay.
Second one, as per direction of this honorable court, Lord. Whether that 311(2) has been mentioned in this affidavit or not, Lord, I will, Lord, place
Okay.
that paragraph, Lord. It starts from page 44. Now paragraph 5, page 47. You can skip the first paragraph, page 48, second paragraph, regarding service of debt termination order and other aspects, Lord. First, that vigilance case, Lord, and so, Lord, I will skip that para. Page 48, internal para 5, page 5, second para. Mary. It is humbly stated by this deponent that the said notification, that termination notification, dated 25/9/2021, has been immediately uploaded in the Guwahati University's official website for information of all concerned. And the media has also widely covered as well as circulated about the entire episode, leading to the writ petitioner's arrest and termination from his service. Further, the writ petitioner has also been duly intimated officially about the termination of his service through a speed post communication dated 27/9/2021 from the Guwahati University Post Office, pin number so-and-so, along with the aforesaid notification communication. It is in tune with the section 27 of the General Clauses Act, Lord. I'll refer those law, Lord, a little bit later. However, the said speed post communication has been returned unserved with a note in this regard. Upon the envelope containing the communication from the postal staff concerned dated 1/10/2021, it is stated that from a perusal of the relevant postal records, it is also clear that on 29/9/2021 and on 30/9/2021, the writ petitioner's house doors were closed, and on 1/10/2021, it has, next page, it has been noted by the postal staff that the addressee was out of station for a long time, and hence it was returned to the sender. It is humbly stated that from the contents of the writ petition, including the writ petitioner's purported failed attempts to enter the Guwahati University campus, as well as wide media coverage and the Guwahati University official website publication, it is obvious that the writ petitioner has been well aware of his termination order and craftily avoided asking or receiving the same till the end of his contractual engagement on 31/12/2021. It is very, very important, Milord. His contractual agreement ended on 31 December 2021. He moved this honorable court after long 6 months on 27/6/2022, after expiry of his contractual term. Designing an unethical strategical move to be resorted to in the days to come. On the other hand, it would be relevant to point out here that the writ petitioner has personally visited the office chamber of the Registrar Guwahati University to submit the order dated 30/6/2022 of this honorable court, and also made the registrar with a representation on 1/7/2022. It is stated that the writ petitioner could have come to the university to know the status of his service had he wished to do so at the university, because
he has been restricted only, it is important, my lord, he has been restricted only to enter the university campus, but not debarred as per the aforesaid notification. Moreover, it may be stated here that a writ petitioner being proficient in computer, paragraph number 5 and 6 of the writ petition may be referred to, would not be unaware about the aforesaid termination notification, though he has projected himself having been selectively unaware about the said termination notification. He is also a computer typist. It may also be pointed out here that in the concluding portion of the writ petition, particularly in paragraph number 18 and 19 of the writ petition, the writ petitioner, next page, Miller, has not made any whisper about the purported non-receiving of the termination notification communication, though he has elaborately explained about the same in the earlier portion of the writ petition. Next paragraph. It is stated that having issued the termination notification or communication dated 25/9/2021, the university authority concerned in the office of the secretary, university classes, has also communicated, approached the writ petitioner for the purpose of obtaining the keys of office almirahs without any fruitful result, since he has purposefully sought to be not available, and his mother has also refused to cooperate with the GU staff in this regard, which will be clear from the perusal of the relevant records maintained in the secretary office. Next para. It would also be relevant to point out here that this honorable court, by an order dated 18/11/2021, it is important, Lord, that date, 18/11/2021, in bail application number so-and-so, Sasanko Soikia, the writ petitioner versus State of Assam, has granted bail to the writ petitioner, but in spite of that, he has not approached the Guwahati University authorities concerned for several months till submission of an RTA application in the first part of March 2022. His contextual engagement has ended in 31 December 2021. His bail has been granted prior to that on 18/11/2021, but he chose to be remain Millard unconcerned about all the developments, and only in the first part of March he has prepared an RTA application and moved this honorable court in the last week of June 2022 after 6 months. Next para, page 51, Millard, para 6. That with regard to the statements made in so and so, while putting the writ petitioner to the strict proof thereof, this deponent humbly begs to state that the writ petitioner has submitted an application dated 2/3/2022 after expiry of the term of his contractual engagement on 31/12/2021 under the Right to Information Act so and so, Annexure J to the writ petition, which has been promptly responded by the Public Information Officer of the Guwahati University through his reply communication dated 2/3/2022, sent in speed post. But intentionally, the writ petitioner has refused to receive the same, which is clear from the note dated 7/3/2022 of the postal staff concerned upon the envelope containing the said RTA reply communication, as well as the relevant postal records in this regard. Next para. The writ petitioner, during and even at the end of his judicial custody period, curiously has not approached the Guwahati University authorities concerned as regards the aforesaid termination of his contractual engagement, which engagement was to end on 31/12/2021 as per the term extension order dated 27/7/2021 through his former colleagues. Contents of the instant paragraph number so and so of the writ petition may be referred to. Next page, Miller. And or through any postal communication without even resorting to entering the university campus for that purpose. It is stated that though the writ petitioner has all along been in the know, rather well aware of the termination notification or communication dated 25/9/2021, it is still in the official website of the Guwahati University for last several months, has embarked on the aforesaid RTI way on 2/3/2022 after more than 5 months, having his extended term of contractual engagement expired long back, and started filing representation dated 2/5/2022 so that principles of natural justice, etc. could be invoked resulting extension of his term of contractual engagement to an indefinite period with initiation of a long-drawn departmental inquiry. Surprisingly, no appeal under the provisions of the RTA Act has been filed as regards the purported non-response to the writ petitioner's RTA application dated 2/3/2022 till date. Next, para 7 page 10. Internal page 10, running page 53. That with regard to the statements made so and so of the writ petition, while putting the writ petitioner to strict proof thereof, reiterating the statements made herein above, this deponent humbly states that under the peculiar facts and circumstances of the instant matter, with the appertaining chronology of events, the writ petitioner is not at all prejudiced due to the termination of his contractual engagement with effect from 25/9/2021, and further, the writ petitioner is also not entitled. It is very important, Milord. There is a mentioning of Article 311(2), but my learned friend Milord pointed out that no mentioning has been done in the first affidavit. The writ petitioner is also not entitled to any protection under the provisions of Assam Services Discipline and Appeal Rules 1964 and or the inquiry provision under Article 311(2) of the Constitution of India prior to the said termination, which has also been accepted by the Executive Council, the highest executive body of the university, exercising its power under the Guwahati University Act 1947 as amended. Further, this deponent humbly begs to state that in the appertaining factual matrix, the writ petitioner has willfully suppressed as well as misled this honorable court as regards the following material facts having vital bearings in the instant writ proceedings. 1. The writ petitioner has stated in the writ petition that as on date, under quotation, Milord, as on date, the petitioner has not been officially communicated about his termination by the officials, next page, of the Guwahati University. Paragraph number 15 thereof. And since, under quotation, till date, no response has been forthcoming from the authorities in respect of his RTA application dated so and so regarding not allowing to work in his post, the situation purportedly has come to such a pass that it is only after running from pillar to post, it is under quotation, Milord, from the writ petition. It is only after running from pillar to post that the petitioner could now somehow procure the aforesaid MTU notification dated 25/9/21 from reliable but unofficial sources. Paragraph number 16 thereof. However, the formal and due approaches of the Guwahati University authorities on several occasions, including speed post communication of his service termination notification, speed post communication of the RTA response, physical personnel visits to his house as regards keys of the office almiras, have been purposefully negated, those having been culminated with either door locked, out of station, not available stays, or got refused on the part of the writ petitioner and or his family member. Relevant records of postal reports as well as the Guwahati University staff's reports may be referred to. We have annexed those reports, Milord. It is humbly stated that these approaches of the university authorities are in tune with the long maintained relevant practices as well as existing laws of the land, including the Assam General Clauses Act 1915. In General Clauses Act, Milord, Central General Clauses Act, it is section 27 regarding postal service, Milord. And in Assam General Clauses Act, it is, Milord, section 30. Next page. Page 55. Further, the writ petitioner is well versed in computer arena. Paragraph number 5 and 6 of the writ petition may be referred to. And being a computer savvy person who has been actively engaged in computer related works in the university, it is strange that he has been selectively unaware about the termination notification, which is still available in Guwahati University official website. 2. That the response communication of the PIO, Public Information Officer, of Guwahati University as regards petitioner's RTA application dated so and so has also been refused to be received Though it has been projected by the writ petitioner that there is no response. It may be pointed out here that though there has been purportedly no response to his RTA application, the writ petitioner has not submitted any appeal for the same under the provisions of the RTA Act, which is the normal practice under the existing circumstances. 3. That the writ petitioner was granted bail by this honorable court on 18/11/2021 in BA number so-and-so, which has not at all been indicated in the writ petition and has chosen to bid his time till the expiry of his extended term of engagement, devising and plotting a crafty game plan, and ultimately has approached the university authorities much later with an RTA application dated 2/3/2022. Next para, page 56. That the writ petitioner has stated in the writ petition that he is not even allowed to enter the Guwahati University campus, and that even his entry within the Guwahati University is barred. Paragraph number 17, 18, 19 thereof. On the other hand, the writ petitioner has personally visited the office chamber of the registrar and submitted his representation dated 1/7/2022, along with this honorable court's stay order dated 30/6/2022, without any objection from the university authorities. In fact, the writ petitioner's entry in view of the prevailing circumstances has been restricted only and not barred as intentionally projected by him in the writ petition. Since, my lord, that police inquiry was going on, so, my lord, that APDCL scam, so, my lord, my lord,
What is the difference is restricted and barred?
my lord, barred, my lord, is, my lord, totally, my lord, totally, my lord, barred to enter,
And it restricted
partially barred, my lord.
per se.
My lord. So, my lord, since, my lord, that inquiry was going on at that time, that police inquiry, that APDCL scam, my lord, my lord, so, my lord, that was, my lord, for preventing the petitioner and other, my lord, employees who have been, my lord, terminated. So, they were restricted, my lord, not barred. So, even if we assume
That vigilance case, that vigilance is not related to Guwahati University. It was related to APDCL.
APDCL, my lord. But in spite of that, my lord, since, my lord, police officials have come to the university and collected the documents, my lord, voluminous documents, I'll refer to those, my lord, episodes a little bit later, my lord. Since, my lord, he has been restricted, and so the projection is that it's a stigmatic order, so national justice must follow. So search sheet, inquiry, departmental proceeding, suspension, all these aspects will follow. I will come to that little bit later. Even if it is stigmatic, my lord, then also that proviso 2 of 311(2) would be applicable, and that Tulsiram Patel's Constitution Bench judgment would be applicable, my lord. I will come to that little bit later, my lord. Even if it is stigmatic, and his contractual engagement is to end after 3 months, my lord. He was terminated on 25/9/2021, and his contractual engagement is up to 31/12/2021. Only 3 months left, my lord. Now, next para, my lord, down below, page 56. This para 5, my lord. That the writ petitioner has not made any whisper in his writ petition that his term of contractual engagement was extended on 27/7/21 only for 6 months, and as such his service was no more, with effect from 1/1/2022. He was totally silent about this, my lord. The very vital bearings in the entire, my lord, writ proceedings, my lord. This deponent humbly states that as per the office order dated 27/7/21, writ petitioner's term of contractual engagement was extended for another period of 6 months, with effect from 1/7/2021, and therefore his service term was to expire on 31/12/2021, and the writ petitioner was no more in the service of the Guwahati University since 1/1/2022, which aspect has not at all been indicated by the writ petitioner in his writ petition, consequently suppressing a vital material fact, next page, my lord, from this honorable court. On the other hand, service termination notification has also been issued with effect from 25/9/2021. As such, the matter has already become infructuous and of academic interest only, the writ petitioner having been out of the service long back without any discernible as well as conscious effort to move against the said termination in any forum, including this honorable court during the relevant period, and in view of the instant factual and legal metrics, it is humbly stated that this honorable court may not like to issue a futile writ, exercising the power under Article 226 of the Constitution of India in the instant matter. This deponent, next parameter, this deponent humbly states that as a part of a crafty design, the writ petitioner has recently moved the instant writ petition bearing so and so with an intention to procure stay order as regards the aforesaid termination of his contractual engagement. And for that purpose in mind, the writ petitioner has willfully and intentionally suppressed some vital facts in the writ petition, which have got material bearings in the writ proceedings. It is stated that the Honorable Apex Court and the courts thereunder, including this Honorable Court, have on numerous occasions deprecated such practices in clear terms and propounded that one will have to come with clean hands before the court praying for any relief to be granted by the court. This deponent, in view of the aforesaid facts and circumstances, especially states that instant writ petition so and so may be dismissed in limine with cost. Now, my lord, his appointment order, my lord, page 59, annexure 1. Office order, it is dated 26/1/2016, my lord. With reference to their application for the post of LD assistant, as per recommendation of selection committee in its meeting held on so and so, subsequent approval of the Honorable Vice Chancellor on so and so, following candidates are engaged as LD assistant in offices places as shown against their names as given below. Now, serial number 3, my lord. Page 59, serial number 3, Sasanko Soikia, Secretary Office. It is dated 26/6/2016, my lord. Next page. My lord, the terms of engagement, my lord. It is important to this writ proceeding, my lord. Page 60. 1. The engagement is subject to the following terms and conditions. 1. The engagement is on purely temporary and on contractual basis, initially for a period of 1 year, and may be terminated at any time without assigning any reasons thereof. May be terminated at any time without assigning any reason thereof. That Sri Lekha judgment is there, my lord. Reason must be there, but in the termination order, that reason may not be reflected, my lord. At any time, it means during the relevant period, my lord. At any time, without assigning any reason, he may be terminated. Now, serial 4. The engagement is subject to getting the character and antecedents to be verified from the police authorities. The police authorities have arrested him on 25/9/2021. Next page, my lord. Annexure 2, page 61. Serial number 3. His extension order, my lord. Annexure 2, page 61. Serial number 3, Sasanko Soikia, Secretary Office. Date of effect 1/7/2021. As per approval of the Honorable Vice Chancellor so and so, the term of engagement of the following LDAs are on contractual basis is hereby extended for another period of 6 months, with effect from date as mentioned against their names. So, my lord, the date of effect 1/7/2021. So his contractual engagement was to expire on 31/12/2021. About which annexure, my lord, about the contents of this, my lord, letter, extension order, entire writ petition is silent. Next page, my lord. It is the termination order. The second para. In view of the above, the service of Sasanko Soikia, so and so, has been terminated with immediate effect as per clause number 1 of terms and condition of his appointment order dated 21/2016. So to be terminated at any time without assigning any reason thereof, that term has been used, my lord. And moreover, as my learned friend already pointed out, the entry of the above 3 persons is restricted inside the Guwahati University campus henceforth. This is issued with the Honorable VC's approval dated so and so. Now, during the course of argument, my lord, this Honorable Court directed the Guwahati University, respondent Guwahati University authorities, my lord, to file an additional affidavit regarding the second proviso to Article 311(2), why termination order has been issued without holding any inquiry, my lord, and the records, my lord. So, my lord, I have filed this affidavit, my lord, on 6/6/2024. It starts from page 106. Paragraph 3 onwards, my lord. Page 107. Page 107. These 3-4 pages, my lord, are very, very important regarding that, particularly revolving around that termination order without inquiry. Paragraph 3, 107. I'll read it slowly, my lord. That the deponent humbly states that an affidavit in opposition on behalf of the aforesaid respondents has already been filed on 28/7/2022. Running page 107, my lord.
Got it.
Stating inter alia that after expiry of the extended term of contractual engagement long back, that is on 31/12/2021, the writ petitioner started filing representation for the purpose of initiation of a long-drawn departmental inquiry that, with the appertaining, next page, my lord, chronology of events, the writ petitioner is not at all prejudiced due to termination of his contractual engagement with effect from 25/9/2021, and further, the writ petitioner is also not entitled to any protection under the provisions of the Assam Services Discipline and Appeal Rules 1964 and or the inquiry provision under the Article 311(2) of the Constitution of India prior to the said termination. Also, it has been stated in the said affidavit in opposition that the writ petitioner has not indicated in his writ petition that his service term was to expire on 31/12/2021, consequently suppressing a vital material fact from this honorable court, and that the matter has already become infructuous and of academic interest only. Next, paragraph 4. That the deponent states that this honorable court by an order dated 28/5/2024 in the aforesaid WPC number so and so, after hearing both the sides, has
Is there any bar in the Assam Services Discipline and Appeal Rule 1964 in respect of conducting inquiry
my lord,
in respect of contractual employee?
my lord, regarding any employee, my lord, including contractual employee, my lord, in tune with that Article 311(2) second proviso, my lord, termination order can be issued if there are reasons, my lord, without citing 311(2) or 7, 8, 9 of Assam Services Discipline and Appeal Rule. Without citing those sections, my lord, some authority can terminate any employee, contractual
8 and 9.
7, 8, and 9. my lord.
Sorry.
regarding Rule 7, Milord, Assam Services Discipline and Appeal Rule 1964. 7 contains the nature of penalties, including censure, termination, compulsory retirement, removal, dismissal, etc. And Rule 8 is regarding disciplinary authority. Who can issue that termination order? And Rule 9 is procedure.
You say here the word termination, not even.
Yes, Milord. But
Is equal
there,
to which of these functions?
Milord, the
Rule
last
7.
one, Milord, dismissal.
Subclause 7, my lord. Rule 7, subclause 7. Dismissal.
Dismissal, Milord.
It's the harshest penalty, my lord.
If removed, then he can, Milord, can be engaged in future in another, Milord, employment, Milord. But dismissal, Milord, no employment in future. So 8 is the disciplinary authority, 9 is the procedure for imposing penalties, that search it, departmental proceedings, etc. Milord. And most importantly, the next rule, Milord, Rule 10. It is in tune with Article 311(2), Milord, the provisos. Notwithstanding anything contained in Rule 9, Rule 10, Milord, where a penalty is imposed on a government servant on the ground of conduct which has led to his conviction on a criminal charge, or the second one is important, Milord, 2(10)(2), where the disciplinary authority is satisfied for reasons to be recorded in writing that it is not reasonably practicable to follow the procedure prescribed in the said, or where the governor is satisfied that in the interest of the security of the state, it is not expedient to follow such procedure, the disciplinary authority may consider the circumstances of the case and pass such orders thereon as it deems fit, provided that the commission shall be consulted. It is not important. This is commission APSC, Milord. If APSC selected and appointed, Milord, then that will be relevant, Milord. This 2(10)(2), it is perimeteria to the provision incorporated in Article 311(2), dispensing with the inquiry departmental proceeding, Milord. So, Milord, I agree, Milord. If a person is even in the contextual engagement, Milord, this Rule 10, it would be applicable. But 7 to 10, Milord, since Rule 10 is the exception, Milord, and it is in tune with Article 311(2), Milord, I'll come to that article, Milord. Constitution. May I read that Article 311(2), Milord? I think prior to that, Milord, this affidavit. But that proviso, Milord, that has not been indicated, Milord. So,
Okay.
prior to that, Milord, may I, Milord, this contents of my affidavit, Milord? May I read, Milord? 2-3 pages, Milord. Very relevant to the instant proceeding, Milord. It is perimeteria, Milord. There's Rule 10(2), Milord. It is perimeteria to that Article 311(2), second proviso, Milord. If it is not reasonably practicable.
Okay.
Next page, Milord. First, Milord, this 9, 10, 11. Then, Milord, it started 9, 8, 10, Milord. After 11, Milord, in the book, this 9A and 10. Next page, my lord.
Okay.
9A is the communication of order. And 10, my lord, special procedure. Possibly that word said, it should be same, my lord. SAID said. Last word. And
This deletion should be mentioned in which order? In termination order?
Yes.
my lord,
Uh,
if it is not mentioned, my lord,
Then-
then Supreme Court is clear, power must exist, but it may not be reflected. If it is not mentioned, my lord, then for that reason, it is not invalid in the eyes of law. As per this 5 judges Supreme Court, the-
which this is?
Tulsiram Patel, my lord.
Sir.
My lord. That will not be allowed by the law of body. Paragraph 125 and 126. my lord. So this entire judgment in Tulsi Patel, it's around 150, more than 150 pages, my lord. 5 judges constitution bench very beautifully explain all the provisions under Article 311, 2, my lord. It starts from page 398,
That's all right. Oh, which is the relevant paragraph?
paragraph 125 and 126. May I read, my lord? It is regarding non-mentioning of that particular section or provision, my lord. May I read, my lord? Page 500, my lord.
But it not relates to region. It relates to the provision.
So, my lord, reasons must exist. Reasons are there, my lord. So, I'll
In the termination order.
no, not in the termination order. That is why, my lord, there are several other paragraphs also. I'll refer to them, my lord, one by one. Reasons must exist, but those reasons, my lord, could not find place in the termination order. Even in that case also, my lord, it is not invalid. But reasons must exist in the records. I'll refer to those paragraphs a little bit later, my lord. First, this 125 and 126.
Okay.
May I read, my lord?
Yes.
Page 500. Some of the orders impugned before us refer only to one or the other of the 3 clauses of the second proviso to Article 311(2). For dispensing with an inquiry without referring to the relevant service rule, it is important, my lord. Dispensing with an inquiry without referring to the relevant service rule, some refer both to a clause of the second proviso and the relevant service rule, while the others refer only to the relevant service rule without making any mention of the particular clause of the second proviso which has been applied. The question is, this is important, my lord. The question is whether the omission to mention the particular clause of the second proviso or the relevant service rule makes any difference. Answering that query, my lord, next para 126. As pointed out earlier, the source of authority of a particular officer to act as a disciplinary authority and to dispense with the inquiry is derived from the service rule, while the source of his power to dispense with the disciplinary inquiry is derived from the second proviso to Article 311(2). There cannot be an exercise of a power unless such power exists in law. If such power does not exist in law, the purported exercise of it would be an exercise of a non-existent power and would be void. The exercise of a power is therefore always referable to the source of such power and must be considered in conjunction with it. The court's attention in Salappan case was not drawn to this settled position in law, and hence the error committed by it in considering Rule 14 of the Railway Servants Rules by itself and without taking into account the second proviso to Article 311(2). It is also well settled that where a source of power exists, the exercise of such power is referable only to that source and not to some other source under which were that power exercised. The exercise of such power would be invalid and without jurisdiction. Similarly, if a source of power exists by reading together two provisions, whether statutory or constitutional, and the order refers to only one of them, the validity of the order should be upheld by construing it as an order passed under both those provisions. Further, even the mention of a wrong provision is important, my lord. Further, even the mention of a wrong provision or the omission to mention the provision which contains the source of power will not invalidate an order where the source of such power exists. Some case laws have been mentioned, my lord. The omission to mention in impugn orders the relevant clause of the second proviso or the relevant service rule will not therefore have the effect of invalidating the orders, and the orders must be read as having been made under the applicable clause of the second proviso to Article 311(2), read with the relevant service rule. It may be mentioned that in none of the matters before us has it been contended that the disciplinary authority which passed the impugn order was not competent to do so. So, omission or wrong mentioning of the relevant provision.
No, that's all right.
My lord.
There is
Then,
no
my lord,
dispute about it, but the question is whether
the reasons
Reason,
exist,
yes.
my lord.
Yes.
For that, my lord, another paragraphs dealt with that
Okay.
aspect, my lord.
Okay, where?
My lord, paragraph 128 to 130, my lord. 130. First, my lord, 128 to 130, little background regarding that, whether reasonably practicable or not, my lord. Where
is the finding upon that point?
Miller, regarding this Miller reasons, Miller, 133 and 134.
Okay.
Page 505. Mary.
Yes.
The second condition necessary for the valid application of clause B of the second proviso is that the disciplinary authority should record in writing. The disciplinary authority should record in writing its reason for its satisfaction that it was not reasonably practicable to hold the inquiry contemplated by Article 311(2). This is a constitutional obligation, and if such reason is not recorded in writing, the order dispensing with the inquiry and the order of penalty following thereupon would both be void and unconstitutional. Now, next paragraph. It is paragraph 134. It is obvious that the recording in writing of the reasons for dispensing with the inquiry must precede the order imposing the penalty. Now, it is very, very important, these two sentences, my lord. The reason for dispensing with the inquiry need not, therefore, find a place in the final order. My lord, ditto to this termination order, my lord. The reason for dispensing with the inquiry need not, therefore, find a place in the final order. It would be usual to record the reason separately and then consider the question of the penalty to be imposed and pass the order imposing the penalty. It would however, be better to record the reason in the final order in order to avoid the allegation that the reason was not recorded in writing before passing the final order, but was subsequently fabricated. So, my lord, that is why, my lord, this,
File is available.
my lord, little problem, my lord, I have, that has been sent back, my lord, since it's almost 1 year, last arguments, my lord. So, my lord, if
Now.
another date may be fixed,
Justify it by showing the file.
my lord. So I'll have to produce the records, my lord, the relevant records. Another date may be fixed, my lord. Only on that point, my lord.
But it
I
has
have
to be
sent
the
back the
original record, not loose sheets, my lord.
Yes, original file.
Original record.
So that loose sheets on do, my lord.
Better you produce the entire file.
Original record, my lord.
Sir, overall learned for the something process for the respondent. Heard it part will this the matter of when
Next week, my lord. 11th of November. Pariba? 11th. Very good.
11.
No, 18th o'clock.
কিন্তু বেশি লম্বা হয়ে যাবে
On 11th, my lord.
11.
interim order passed earlier may continue. my lord.
Okay, interim order passed. Yeah.
Most of
Item number 13, Lordship. My learned senior friend on last occasions want to file affidavit, Lordship, but
Lord,
till date they have not filed.
my lord. Some time will be required, my lord.
Item number 13.
13, 1-3, Lordship.
Okay, just agreed by learned that the matter on
A date may be fixed, Lordship, because
I
it
will
is
say-
pension matter.
Okay.
Any date convenient to your Lordship. A date.
Vacation. Oh,
in the
Deeply.
meantime, Mr. Bhutan, you have to file affidavit.
yes, my lord.
Mr. Bhutan can file the affidavit.
Most
Deeply obliged. Deeply obliged.
sorry. Okay.
And it's a covered matter. Covered matter. Covered matter under Punima.
Okay, then we will first the.
Only my lord, this area salary part, my lord, which I prayed for also. One of the delay. Apart from pension, my lord, area salary, so that may be obliged, lord. May please, lord.
Lordship, this case is for bringing my service under old pension rules, Lordship. The Lordship has already had my case, Lordship, and nothing new exists, Lordship. The fact is that, Lordship, initially I was appointed on 25 December 1991, Lordship, as ad hoc employee, Lordship, as a laboratory assistant, Lordship. Thereafter, Lordship, an advertisement was issued, Lordship, on 19/7/1992, page 66 in my reply affidavit, Lordship. And then, Lordship, a committee was constituted to Lordship to appoint regular appointment, to issue regular appointment, Lordship, and accordingly, regularization order was issued, Lordship, which is at page 21 of my petition, Lordship. Thereafter, Lordship, for the official exigency, Lordship, I was again appointed as LD assistant cum typist, Lordship, in the year 1996, Lordship. And then, Lordship, a screening committee was constituted to regularize this employees, Lordship, and accordingly, I was also regularized, Lordship. I was regularized on two different occasions, Lordship, earlier in the year 1994 and in the year 2013, with effect from 2007, Lordship. Here, Lordship, I would like to put your Lordship's attention on, Lordship, the regularization order, Lordship. Regularization order is at page, Lordship, 21. Page 21. Page 21. No, not page 21, Lordship. Page, Lordship. Page 30, Lordship. Page 30. Page 30, Lordship. Serial number 9. Serial number 10.
Page 21.
No, Lordship. Page 21 is, Lordship. Page 21 is, Lordship. Page 21 is regularization order, Lordship. Page 21 regularization order. This was issued by the Director, Lordship. A committee was constituted, Lordship, which I annexed in my reply affidavit, Lordship. Committee constituted page 68. Prior to issuance of this regularization order, Lordship, a committee was constituted. Before that, Lordship, there was selection procedure, Lordship. I annexed the select list, Lordship, in my reply affidavit, Lordship.
Page number?
Lordship. Select list, Lordship.
Yes.
Select list, Lordship, page 69. Page 69, Lordship. In my reply affidavit. Select list, page 69. Select list, page 69. My name is at page serial number 51. Then committee constituted, Lordship, page, Lordship, 68. A selection committee with the following members is hereby constituted for selection of suitable candidates for regular appointment for the post of laboratory assistant in the office of the principal, so and so, Lordship. Thereafter, that regularization order was issued, Lordship, in the year
Page number?
1992. Regularization order is at page, Lordship, 21. Page 21. Page 20. It was issued by the
No, no,
Director.
you have submitted that regularized on 2 occasions.
Look, 2 occasions, Lordship. Initially as laboratory assistant on, Lordship, page, Lordship, 21, 18/6/1994, Lordship. After the
Thereafter?
selection procedure, Lordship. And thereafter, Lordship, what happened, Lordship, I was again appointed, Lordship, for official exigencies, Lordship, as LD assistant cum typist, Lordship. Same pay scale, Lordship, but temporarily appointed, Lordship, which is at page 22. Page 22, Lordship. Lordship, here, subject to termination and without notice and assigning any reason thereof, Sri Vinod Chandra Bora, laboratory assistant, is hereby appointed temporarily as LDA cum typist. Before that appointment, Lordship, I was a regular employee under the same establishment, and I was appointed on same pay scale, Lordship. Then, Lordship, may kindly come to the page number 25. Page 25, Lordship. Screening of non-gazetted ad hoc employee under SCRT Assam. Committee constituted. To select suitable candidates among 36 ad hoc employees, Lordship. And accordingly, Lordship, the order, Lordship, page 30, type copy, Lordship. Page 30, Lordship. Amongst other, Lordship, 4 are peculiar, Lordship. One is myself, serial number 9, 10, 13, and 21, Lordship. We all were earlier as laboratory assistant, Lordship. Our post were thereafter we were appointed as LD assistant, Lordship, same sanction, Lordship. We were appointed in sanction post, Lordship, substantive post, Lordship. These 3 petitioners, Lordship, approached before this honorable court, bringing their service under all pension rules, Lordship. And accordingly, following the court's order, Lordship, their pair have been considered, Lordship. I have annexed it as page number 51. Page number 51, Lordship. Regarding allowing pension and other retirement benefits under the Assam Service Pension Rules 1969 to Sri Mukunda Deka, laboratory assistant, SCRT Assam, and Homeswar Kolita, LDA cum typist, and the director of SCLT, Lordship. Now, Lordship, may kindly, again, Lordship, page 30, Lordship. Page 30, Mukunda Deka is serial number 21, and Homeswar Kolita is serial number 13, Lordship. Page serial number 13. Government sanction number same, Lordship. They have been allowed pensionary benefit, and date of appointment also similar, Lordship. Same, 30 January 1996, Lordship. 1996, Lordship. This is only my case, Lordship. And Lordship, I have categorically denied the averments made in the affidavit in opposition, earlier affidavit in opposition filed by the respondent number 2, Lordship. Very recently, they have filed another one affidavit in opposition, my same stand, Lordship. And in this regard, Lordship, I'd like to, Lordship, one more thing, Lordship. I had GPF subscription, Lordship, which were started with effect from 1997, and it was closed on September 2013, Lordship. Starting balance sheet I have annexed. These are page, Lordship. Page 28. And this is the last one, Lordship. Last. And here in this case, Lordship, I rely on a very recent judgment of Honorable Supreme Court, Lordship. With regard to pension and pensionary benefits to temporary and ad hoc employees, Lordship, Honorable Supreme Court has been criticizing the states on the different occasions, Lordship, starting from the Prem-Singh, Lordship. I have one recent judgment that is, Lordship, Lordship. It is categorically stated, Honorable Supreme Court. It is unfortunate that the state continued to take the service of the respondent as an ad hoc employee for 30 years, and thereafter now to contend that that as the service rendered by the respondent are ad hoc is not entitled to pensionary benefit. The state cannot be permitted to take the benefit of its own wrong, to take the service continuously for 30 years, and thereafter to contend that an employee who had rendered 30 years continuous service shall not be eligible for pension is nothing but unreasonable as a welfare state. The state as such ought not to have taken such a stand, Lordship. In the present case, the High Court has not committed any error in directing the state to pay pensionary benefits to the respondent who has retired after rendering more than 30 years of service. My case is more better, Lordship. I was regularized on 2 different occasions, Lordship. In the year 1994 and in the year 2013, which is before 2007, Lordship. And Lordship, if your Lordship, come to the history of regularization, Lordship, I have not, judgments are not available with me, Lordship. Umadevi first case, Lordship. In Umadevi first case, states were directed to regularize as a one-time measure, Lordship. And accordingly, our state regularized approximately 34,000 employees, Lordship, and they are getting pensionary benefit. And Umadevi 3, paragraph number 53, Lordship, there are 3 conditions, Lordship, for entitlement of regularization. And in my case, Lordship, my petitioner says fulfill all the conditions, Lordship. He has qualification, he was appointed in a substantive post, Lordship, and there is, Lordship, selection procedure, Lordship. So, my Lord, my humble submission before a Lordship is that I am entitled to pensionary benefit as per, Lordship, old pension rules, Lord. This is only my case, Lord. I put emphasis in my case that on my regularization order in the year 1994, Lordship, and the entitlement of pension by 3 other similarly situated persons, Lordship, which I have annexed, Lordship. Okay. All right, Lordship.
Come to page number 15, his initial appointment. Okay. The institution. Page number 15, Annexure A.
There is no selection process. Subject to termination and without notice and assigning any reason. Thereof, be so and so, an outsider manner is hereby appointed ad hoc basis and laboratory. He is not, there is no selection process, nothing. An outsider was appointed and he continued. This is the basis of his appointment. There is no selection process and he continued. Thereafter, again in page number 22, my lord, since he continued without any selection process, again in page number 22, he was taken as a subject to termination without any notice and assigning any reason thereof, so and so. Laboratory is being hereby appointed as temporary LDA cum typist. He was also, second time he was also accommodated as LDA typist. And he continued. And present, and he presently he's challenging in this petition is the order dated 4/9/2013. Not will find in page number 30. The type copy is there. 30. Originally it start from page number 32. Entire name is there, my lord. Let us go to page number 30, my lord. The type copy, my lord. This is order dated 4/9/2013. How he is regularized subsequently with a pursuant to a government order. In pursuance to government letter number so and so dated 17/5/2010, which was concurred by the finance department by FCU number so and so dated 17/8. Now the finance department giving a sanction. And pursuant to Honorable High Court order dated with petition number so and so. There were 3 petitions, 2 petitions are given, my lord. The ad hoc service is still ad hoc on the order. Ad hoc service, the following 34 employees under the director of SCRT are hereby regularized with effect from 27/3/2007. Moment he comes under regularization on 27/2007, after 1/2/2005, he will come under new pension scheme. He is regularized with 27/3/2007 under new pension rule. Again, the sanction post and so government and so these are the, and the person's name is in serial number 9. Now next after the column, my lord, this has cancelled the earlier order issued by memo number so and so. That is so and so. It is the concerned employee must submit their undertaking as per prescribed format under a new pension. They have therefore they have to do it, and this order is for 4/9/2013. So they were basically an ad hoc employees, and based on the order of the Honorable Court, my lord, that order, lordship, he has enacted, my lord. It starts from page number 35 onward. There are 3 petitions. Is based on this 3 petition direction to consider the case of the petition in paragraph number. Lordship, find the paragraph number 20, page number page number 49, paragraph number 25. There were direction to the authorities to make a scheme under whether they falls under new pension scheme or old pension scheme, my lord. So, and ultimately, my lord, now I have filed a subsequent affidavit, my lord, on 12/7/2025, my lord. What will come through after that Honorable Court's order, my lord, that's page number 78. A committee was formed by the SCRT, my lord. 3-member committee was formed, my lord. What will page number 78, running page number 78, my lord. Pursuant to the Honorable High Court's order, the director of SCRT has formed a committee of.
There is no page number 78.
Page number 78, next of 78, running page number 78, my lord. This is the order of the director, SCRT, forming a 3-member committee to look after these 34 appointees on gazette process, whether they will come under the new pension scheme or the old pension scheme, my lord. And page number 78 is the report, my lord.
So for there is no page number 78.
My lord, my affidavit, my lord. Running page number 78, my lord. It was filed on 21/7/2025. Page 78 is the running page, my lord.
So you got respondent number 2 here.
No, sir. Yes, director have formed a committee, my lord.
That's right. Your
I am respondent number 2.
but here There is page number 78.
Furnish a copy, madam. Take on again. It has not come on record. It will get filed long back, my lord. It's on 21/7.
So is it not that affidavit filed by you?
That is on, this is an additional affidavit.
Addi-
Additional affidavit. But it is shown in our system, it is shown, madam. No, otherwise it is not. System shows that this is part of the record, madam. So in our website, there is. There is nothing. Also received it, madam. Received.
So Talukdar, you have received the
I have received lots. I have received lots.
Sapora, you could have informed this court earlier. The court that
Sir, I was expecting by, I thought that is already on record, my lord.
uh, okay, then after some time,
Sure.
the court master will call it from the scene.
Or lordship, we can post it next week, my lord. Since it's a part and matter, my lord.
Next week.
Let's see. Tuesday, lordship. On
Tuesday.
Tuesday, lord. Difficulty.
Or Talukdar. Or CRT.
SCRT.
Ian Sharma po. Number one. Sir, court master for
Number 3, my lord. And then
number 3.
my lord.
Then or po. That's po. Getting sir. Or alternate. Nothing known for the
SCRT.
CRT. Number 2. Here file. That is accepted. Not back to the record. Or third. Taking the affidavit medicinal
Oblan, lord.
or in the side the shepherd by
Lord. Bless you. After challenging a second inquiry. Now, the petitioner had retired in 2022, but for this inquiry, her pension has been stopped. And therefore, the state has to file their affidavit. 2/8/2024, state has taken time to file counter.
Oh, Lordship, I have sent the affidavit for waiting. Lordship, may take it after.
When?
After 10 days, Lordship.
After 1 week, why the third for the SCR.
Yes, ma'am. Lordship may take this matter with same petitioner, 3386/24. I am seeking my pension. I have filed another matter. Both matters may come together. Because for this matter, the pension is kept pending.
Sir, this is the- and it- it- I think there is after 1 week, the board attorney for the number
3386/20.
386 of 2020
24.
2020. There is recorded there. After what?
Deeply.
Interested.
My lord, in this case, I have filed on IA. In last occasion, my lord, the copy has been served to all the respondents, my lord. That is in IA has been filed in view of the, my lord, this is second affidavit filed by the university, by which they have taken a stand that the necessity of the NOC is required from the government before giving the affiliation of the concerned colleges to open their classes. So in comparison to the OM, that is 2019, and their common notification 2020. So, my lord, in this regard, my lord, I have a submission, my lord. This issue, my lord, wherever is involved in this case, it is no longer, my lord, res intriga in view of the, my lord, the Honorable Court's, Supreme Court's decision that is passed on, my lord, CLS case. It is already relied by your lordship in the your lordship two judgments subsequent, my lord, the Hameke College, my lord. I have also relied. So the same issue is involved here also, my lord. So, my lord, this is, my lord, I think there is no further issue to be decided. So, in view of the two judgment, your lordship, that is in passed in WPC 821 of 2024 and 2782 of 2022. Well, that is in the line of the, well, SLC College of Pharmacy and the others, well, Jawaharlal Nehru University of Technology. So, well, this case, well, I think it is a end in that point. The issue is same, my lord. They said that without obtaining the NOC, the government, so there is a conflict between the University Act as well as the, my lord, NCT Act as well as, my lord, the Central Act. So, my lord, the NCT, my lord, 2014 regulation, it is 5.3 specifically stated there is no NOC is required. His lordship has already decided in the case of, my lord, Hameke College of Higher Education, my lord. And regarding the other case also, my lord, the Hameke College of Rural Development Foundation also, the same issue has already decided by lord. My leave to your lordship to decide this case because the issue is the same way.
My lord, some time will be required, my lord, since, my lord, in similar cases, this honorable court has already passed orders, my lord. So, my lord, the effect of those judgments in the present proceeding, my lord, some time will be required, my lord. Next week, the matter may be fixed, my lord. Next week, my lord.
I have no objection, but otherwise, my lordship is to go by the lordship, my lord, this judgment and the issue in
Examine the matter.
my lord.
Let them examine the matter.
Okay, my lord.
Third, we also heard it. Yeah, for Ali for allow for
NCRT,
for
NCT.
NCT. The pair being met by for the standard of
My lord,
Most obliged.
date is given, my lord.
My lord. Monday. Most obliged.
Mass obliged. Yes, yes.
Also by the order dated 19/8/25, instructions were sought. As regards the order 8/4/2024.
My lord. Instruction, my lord, I have inquired about the instruction, my lord. The department has stick on the instruction earlier sent to us, my lord, on in the year 2023. My lord, as he was not regularized, my lord, that he was absent in that period, my lord, and so the department has passed an speaking order, my lord, as no work, no pay, my lord, and
Yes, this is the order which is in my petition. This is a order prior to this order of 8/4/24. 8/4/24 says regularization, do regularization. This is that very old order which I have annexed. That is why I challenged. Then no work, no pay. In between the petition it came. It cannot be because I was before this court. I was not allowed to work. My case was going on. It's a very old one. As per 8/4/24, the instructions were sought for lordship.
For the order dated
8/4/2020, 8/4, my lord, order honorable court asks to why
Why?
why the petitioner was not regularized in the period, my lord, and the department has stick on the earlier order speaking order, my lord, as he was not present in the school and calling him for hearing, my lord, but he absent, hearing also he absent. That's why, my lord.
No, no, no. Lordship,
Okay,
it was
kindly peruse the
why. Order doesn't say why. Order doesn't say why, Lordship. I was in litigation before this honorable court all these years.
No, madam, there is a word in the order dated
Yes, Lordship.
as to why.
Yeah.
The period of purported absence of the petitioner with effect from 1/3/2019.
Lordship.
8/6/2020.
Yes. Now, Lordship, then if they, because they say they are sticking on the same thing, no work, no pay. I have filed this petition against that only, my petition. So if their stand is that not regularizing me, then it will go for full. That matter will be fixed for admission. It may be admitted and hearing may be fixed.
elementary education, my lord. For respondent number
As
one.
stated by Internet Advocate, the word is on
Not 24, just can you give me 2-3 days before? 1 minute. Vote is open, yes. 22nd.
Obliged.
May your lord. Lordship, petitioner was appointed lordship in 1972, lordship. He was in continuous service for 16 years, lordship. They filed the affidavit, lordship. We have admitted fact, lordship. The page number 50, running page 50, lordship. The affidavit, lordship. They are affidavit in opposition. Lordship, paragraph, lordship. Paragraph 4, lordship. May I read, lord? That with regard to the statement made in paragraph 10 to the writ petition, the respondent begs to state that it is clear that the petitioner joined in service on 16th May 2072 and continued up to February 1985. He was given lordship, according to me, lordship, I continued service for 1988, lordship. But after that, lordship, I fall in lordship some nerve problem, lordship, and after in 1995, lordship, I approached the department, lordship, for my that is lordship in
page number 28, Lordship. And in vernacular, Lordship, page number 29, 30, Lordship.
Page number?
Lordship 28, Lordship, in translated Lordship. And in vernacular, Lordship 29, 30, Lordship. In 1995, Lordship, I am pure Lordship, and after that, Lordship, I filed this representation for giving me the to join the service, Lordship. And several representation has been filed, Lordship, but I am not, I am allowed to join, Lordship. Now, my expected retirement was 2013, Lordship. Lordship, I am not paying for pension, Lordship. For 16 years, continuous service, Lordship. 16 years.
What is your stand?
Lordship, as per my affidavit, Lordship, it appears that 13 years he serviced. After that, he was not attending his service. At the same time, petitioner is failed to enlighten that whether he is in the regular post or regular employee of that of the department, Lordship. It is categorically stated in his writ petition that no documents found from his part, Lordship, regarding the position of the post, Lordship, whether it is regularized or contractual or.
Lordship, in 1972, Lordship, there was no ad hoc employment law. I am Lordship, appointed in regular pension post, Lordship. And Lordship, in page number 50, Lordship, they have said that page number 50, Lordship, paragraph 6, Lordship, that with regard to the statement made in paragraph 14 to back to state that it is not possible to trace the original file to provide my information. They have nothing, Lordship.
No, Lordship, this statement is related to his statement in paragraph 14, Lordship. One RTI application was filed, Lordship, for and on that regard, Lordship, this statement was made, Lordship. One RTI application was filed.
Nothing has been.
2013, Lordship, one RTI application was filed.
Yes.
And in the year of 2024, Lordship, it is difficult for us that to trace out that application.
Accordingly, affidavit filed, Lordship, no, not traceable, Lordship, about my service book, Lordship.
Not stated.
According to them, Lord.
Not an letter.
Yes,
Lordship,
not
Lordship,
Not an
not Lordship. That has been, Lordship, in 2000. Lordship, in 1988, Lordship, in the big part of page number 6, Lordship, paragraph 3, Lordship, that has been, Lordship stated, Lordship, the petitioner cannot produce the copy of the appointment and joining report since the documents had been lost during the heavy flood in the area of the petitioner in the year 1988, Lordship. Sipazhar area, Lordship, Dorang district. Documents were washed away by the flood except the application for some leave documents has been found, Lordship. Grade 4 employee, Lordship, very pity condition, Lordship.
why the department
Lordship, the affidavit, so for the affidavit submitted by the department, Lordship, it is not clearly stated all these things, Lordship, but categorically stated in paragraph 6, Lordship, it is to the it is in response to the paragraph 14, Lordship, 14 of the writ petition. In that writ petition, it is stated that on 16/11/2023, that paragraph, it is page 11, Lordship, paragraph 14, Lordship, of the writ petition. Therefore, on 6/11/2013 and 11/12/2013, Nityananda Kolita, who is the friend on behalf of the petitioner, submitted 2 applications under RTI Act 2005 before the respondent, number 2, requesting him for providing 5 information regarding the service of the petitioner, which are as follows. These are the questionnaires. Now, retaliate to that paragraph, it is page 50, paragraph 6 of our affidavit. It is stated that, Lordship, that it is not possible to trace the original file of the file to provide the information which was already informed as per the office letter dated so and so so and so. Now, Lordship, it is not categorically described what is the actual
Lordship,
status, Lordship. On that count, Lordship, I may be allowed to
Call for record.
no, I may be allowed to further instruction regarding this. Is there any is there any record of the petitioner in the department order?
That's that-
But
that- that-
Lordship,
that- yeah,
treasury,
yeah, but-
Yes.
that-
If record is available, then records may be called for.
no, treasury office, it may be. I think finance is not the finance is not
Director.
no, director of pension after director of pension will come after submitting the proposal, Lordship. But treasury, whether during his service, whether from his salary, is there any deduction of the pension for pensionary benefit or not? That may be got from the yes, the treasury maybe.
or that
Yes, Your Honor.
or go for a number.
Lordship, I am on behalf to 1, 2, 3, and 5, Lordship.
Five.
Right.
So okay, done with further time. Of the content on the page or six of the by the or there is according to the after one
Lordship.
Lordship, may I pay for a fixing date? Lord? Much.
Friday, my lord. The senior counsel is Chaudhary will argue and he's on the lake, my lord. So let him on Friday or Monday, my lord. Otherwise, the timing, my lord. And now 3 p.m.
Lord. Lordship, counsel says both of is on lakes. Lordship, may kindly pass over the matter for timing.
Lordship, we have received our instruction, Lordship. 2 weeks time maybe granted for file affidavit, Lord.
By turn- but after the step, then by
Lord.
There is an IA. We have filed it 2 years ago, my lord, almost. So many days have been passed, my lord. They were directed to produce the record because our cases were under process as per our knowledge. Therefore, we pray before this honorable to produce that record. If there are no record, they may file affidavit that can be closed, the IA.
Lordship, although in the main read petition we have filed our affidavit, but there was a direction to produce that record, and that already been communicated to the director, and director in turn has already communicated to the secretary office, Lordship, but that record is yet to be received. Lordship may fix next week.
It may be fixed, my lord. On the next date, it may be closed, my lord.
Lordship.
as agreed by Lord, the part after 1 week.
Lordship.
Part then the correct.
Public.
Date may be fixed. Date next week.
Afterwards. Public.
Here in this case, my lord, retired person lordship, he is, my lord, presently, my lord, 70 years lordship. In 2015, he has retired, my lord. But because of, my lord, anomalies in the name lordship, in service records and the other cards, PAN cards, etc. lordship, he could not, my lord, draw the pensions lordship. Now kindly see, in, my lord, he was initially, my lord, appointed as master role lordship. Thereafter, he was, my lord, regularized in 2005, my lord. As, my lord, Srimanto Das. My lord, thereafter he in service, my lord, he completed, my lord, matriculation lordship. In SSLC examination lordship, he changed his name as Ochud Das lordship. Thereafter, during while in service lordship, he submitted application for correction of records, service records lordship. That application representation kindly see lordship at page 22. Page 22, that was submitted, my lord, on 23/8/1994. Lordship, page 22. My lord, along with this application, my lord, thereafter an affidavit also, my lord, was shown, my lord. It was also, my lord, submitted, my lord, for, my lord, authentication lordship. Thereafter, nothing was taken, my lord, done, my lord. The authorities were sitting about the, my lord, matter lordship. Then I was doing service in, my lord, in this way, my lord, the service was regularized lordship. Subsequently in 2015, I was given retirement lordship. Now, nowadays, my lord, because of digitalized, my lord, system lordship, the link with the bank and the, my lord, Aadhaar cards, my lord, etc. required to be established lordship or real of the pension lordship. But as the pension papers, all service records are in the name of, my lord, both Srimanto Das lordship, and except service matter and pension papers lordship, all other documents, Aadhaar cards, voter IDs, etc., SSLC examination certificates lordship are in the, my lord, name of Achud Das, because my name was changed during, my lord, matriculation lordship. This is the problem. Because of that lordship, I could not draw my pensionary benefit lordship. Subsequently, recently after retirement law, I submitted another application, representation lordship. That is at page 41 lawsuit. At this stage, lordship, I am in very critical condition, my lord, bedridden lordship, because of, my lord, 41 lordship. This is also not decided lordship. Now my prayer, my lord, for a direction, my lord, to correct, my lord, the service record as well as the pension papers, so that I can make establishment, make link with the, my lord, other cards and other documents with the service bank accounts and pension papers, lordship.
Pension payment order was put in your paper.
Sorry, lordship.
The pension payment order was put in your paper.
Yes, lordship, it is in the name of Srimanto Das, lordship. Pension, my lord, kindly see it is at
Yes.
page, retirement order, lordship. First of all, retirement order at page 30, lordship. Page 30. Srimanto Kumar Das. My lord, although I submitted application in 1994, lordship, that was not, my lord, addressed by the authorities, my lord. No order was passed, lordship. The affidavit in reply, the opposition was filed, lordship. In that case, my lord, it is silent. Why this application was not disposed of, lordship? No, I was, my lord, Alashi, my lord, subsequently, my lord, retired as grade 4, lordship.
I don't, what is your step?
Yes, Lordship, we have filed our affidavit. I am representing the department. Lordship, may kindly have a look my affidavit that we have filed from relevant running page 57, my lord.
Yes.
Because he has joined in the service as Srimanto Kumar Das and retired from the service as Srimanto Kumar Das. And Lordship, the annexers that is starts from page 60, annexer 1. Page 60, Lordship has got it, my lord.
Yes.
Annexer 1. This is a letter written by himself, the petitioner, Srimanta Kumar Das. Lordship, his signature is there. Then the executive engineer for prayer for non-renewal of certificate. And he has signed it Srimanta Kumar Das, Lordship. Then the second pension paper, it was approved in the name of Srimanta Kumar Das, the accountant, senior account officer of the Accountant General Office. It was in the name of Srimanta Kumar Das, Annexer 261 page. Then Lordship, the other page 63, it is the order of the executive engineer, IWT Guwahati Division. It is also in the name of Sri Srimanta Kumar, Srimanta Das, retired Khalasi. Lordship, the second paragraph, page 63. Each and every paper is Srimanta Kumar Das. All other papers also, and relevantly page 65, my lord, the relevant portion. 65. Serial number 49, my lord. 65, lordship.
Got it.
Workers list, MR workers list it was, and he was entered as Srimanta Kumar Das, serial number 49. Lordship has got it. Srimanta Kumar Das. And the other paper issued by the Office of the Accountant General, his name was reflected as Srimanta Kumar Das, page 66 also. And the bank details which was given to the submit to the department for other pensionary benefit. It was Srimanta Kumar Das. Customer name Srimanta Kumar Das. It is the SBI account. All these documents, his name is Srimanta Kumar Das. In fact, he has approached earlier before this honorable court regarding his pensionary benefit. And in this matter also, he has approached Srimanta Kumar Das. This is annexer 4, page 69, my lord, page 69. Lordship, the petitioner name Srimanta Kumar Das. Now, nowhere he has mentioned his Ashut Kumar Das or something else. And the last letter, page 72, annexer 5, my lord. This is a letter written to the executive engineer to the joint director IWT division regarding this case, lordship. Sir, with reference to the may I read, my lord, with reference to the subject cited above, I have the honor to inform you that as per our office record, it is seen that Sri Srimanta Kumar Das and Ashut Kumar Das is not same in one person. He joined this office as Srimanta Kumar Das, and after his retirement, he has drawn all his pensionary benefit as Sri Srimanta Kumar Das. So all the documents he has forwarded to the directorate office, and all the documents, his name is as Srimanta Kumar Das, not Ashut Kumar Das. So all the benefit has been released in the account of the Srimanta Kumar Das, the SBI account. SBI account also, his name is Srimanta Kumar Das. And he is joined in service as Srimanta Kumar Das and retired as Srimanta Kumar Das.
Now, what is your grievance?
My lord, that is my case, lordship. In service, my lord, records and the pension papers, lordship, everything, lordship. My name is Himanta Kumar Das. Lord. What was my option? No option was there, my lord, unless I signed, my lord, in the name.
Now you are receiving the pension.
My lord, no, lordship. Because my lord, that is the problem. My lord, in Aadhaar card, my name is my lord, also my lord, Das lordship. That is why link could not be established, my lord. Life certificate could not be issued, my lord, submitted lordship. That is why I have approached before this honorable court, my lord. Yes, lordship, my name is my lord, Srimanta Kumar Das in all service records and pension member. That is why I am before you, lordship. My lord, in 1994, while in service,
Can correct your PAN card and Aadhaar card?
my lord, that will be complicated because it PAN card, Aadhaar card, lordship.
No, then how this
In voter, my lord, voter leads lordship. Also, my name is Achut Kumar Das. In matriculation certificate also Achut Das lordship.
Then
Problem arises, my lord, in during matric.
department this cannot be correct.
yes, my lord. Here, my lord, may I submit? I am appearing on behalf of Accountant General in A&E Assam. When papers were sent for us, that is particularly Form 1A and Form 16, it is name is clearly written Chimanta Kumar Das, and it is to be signed by the petitioner. It was required to be signed by the particular parent. He has signed as a my lordship may peruse statute 51, 52 onwards. Page. Lordship, this is all Chimanta Kumar Das. Now he cannot say it is a due to my this I do not know nothing. Nothing will work out because Form 1A it is signed by him. Form 16 is signed by him. Earlier approached this honorable by him as a Simanta Das. What made him to not to file at that time alias Asinta Kumar Das? Why? Lordship had rightly pointed out because this is he's saying that these documents are public documents. Is the document which was published by him before the account, is it not public document? You have given them authority and difficulties has come for him only because he cannot change it. Bank will not allow him change. It is a question of impersonation, my lord.
My lord,
There is question of personation is coming up. I do not have any problem provided if duly verified, corrected inquiry is made by the department, thereafter is telling. But until unless is given because we cannot change. It is our document, also public document. We cannot, AG cannot change simply because you have, on the basis of your signature, we have done it. From 16, from 1A. That apart, we have issued, my lord, that was, we have issued another things to him. Copy for authority, terminal gratuity also in favor of him. There is Sashwanta Kumar. Now suddenly he is coming, my name is Asinta Kumar. No, it cannot be.
Not suddenly, lordship, in 1994.
1994, then what you were doing from 1994? From 1994, why, what you doing then?
See,
That is the question.
the paper that you have already drawn all the section
On under compulsion, lordship.
That-
Otherwise, my lord, I am not allowed to, my lord, to receive
This
salary.
cannot be, my lord. One way you draw the pensionary benefits gratuity on the edition, another way you do not do. That is bank has rightly pointed out, my lord.
My lord, my lord,
dismiss this petition with having cost.
Yes.
my lord, what I am submitting, lordship.
Unless and until you withdraw it, if obtain instruction.
Otherwise, my lord, I will be, my lord, immediately less, lordship. I will not
Pardon?
get pension, lord.
Pardon?
Otherwise, I will not.
Receiving the pension now.
No, lordship.
No.
Not receiving.
Because,
So
my
these
lord,
letters prove that you
Now,
the
presently
terminal
not receiving.
gratuity he has got it. My lord, what happened? Terminal gratuity we have issued him in favor of PPO Chimanta Kumar Das. PPO we have issued when he has gone to bank. Bank is showing you show your this one. This is not same person. Bank definitely refused. He is not same person. Chimanta Kumar and Asit Kumar. There is a actually there should be an inquiry. How it can be Chimanta Kumar Das become Asit Kumar become Chimanta Das. That
Yes,
is the
lordship.
question.
My lord,
Yes,
personal
my
care
lord,
may be directed
and
to
he
be
is telling
taken, lordship.
1994 he has filed application. Yeah.
Personal
When you have
care
not got
may be directed to
2021 has
take-
filed
I
an
am ready
application,
to appear
then
and-
we were doing so. Where?
you go and make necessary correction in your PAN card and other card.
Yes, if
Yes.
lordship, my lord, direct, I will, my lord.
Oh, how can he can? Oh, this is a bank authority. They will verify and see. How court can direct?
If you lordship direct, lordship, make an observation, I will tell. Otherwise, there will be
No. This
complication.
cannot be made. That to bank is not before lordship.
It may be disposed with some sort of observation.
This cannot be
my lord.
because my lord it will be
Aadhaar card and
prejudiced
PAN card, lordship,
because
on
the
that,
bank
lordship.
is not before lordship.
Then I can do this law.
No. এইটো বেংক নাই লগতে কেনেকে?
In this way, it may be disposed of. Lord. I'll file, try to my
That
lord,
will be
correct
not
my
proper, my lord.
Aadhaar card and.
Generally, we do not object, but we always object about things. We do not object for pension, my lord. I am dealing with for long years. We never object, my lord. But this type of things to be really should be objected, my lord. All along you have approached also earlier Simonto Kumar Das. Now you have, my lord, on the basis of that writ petition, we were bound to give him PPO because Sanjita Roy cases covered his case. On the basis of Sanjita case, we are earlier given the PPO. We considered this one as a Simonto Kumar Das. Now whether it cannot be the same person, my lord, I am telling you.
In 1994, I informed this.
1994 onwards, how many years today?
That is it is clear in the representation.
My lord. See, Bodua for. I am from my lord. Or 5, my lord. Accountant General any Assam.
In which year you have there?
My lord, 2015 loss. On 31/7/2015.
This is after retirement, here the pension was not considered. Then he approached this honorable court. When his pension then terminal gratuity was paid. And all documents was furnished by Form 1A16 and gratuity, all this will be signed by him as a month of.
Declaration by order dated 7/5. In other name, after but but regret by the after it on for and after for it get by or or but or or a third referring if that for record of the point that that and yet quite like quite represent that there are like that all the documents for that was for it like, not for part for that that all like, that further pointed out that also part of it by that they are also like reflected at the state of voice Marta. And there's a for us that this case of the not my photo or that uh,
Affidavit number is file, my lord.
also, uh,
Motion to box of thing.
for the the company that I that the order another that were of that 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 then I find sub aura and for the it appears that the voice part that that a PPO was that it was not that but also and annexer by of the evidence by the transport regard it the has also determined that determinant and so that type of the method is for of the that is not that however that different evade other images evidence
My lord, as regards Aadhaar card, lord, some observation will be. Like. The petitioner was placed under suspension in 2024, 22, 2024, page 16, madam. On some charges of money lending business, madam. In that case, of course, in the criminal case, he has already been acquitted, madam. But here in this, the order of suspension is at page 16, madam. 22 to 2024. Now, my lord, this was, my lord, pursuant to his arrest, my lord, he was put under suspension. And my lord, thereafter, he got bail, my lord, therefore, my lord, he was reinstated, my lord, lordship will say page 28. The suspension order was revoked.
When?
my lord, the authorities, my lord, found, my lord, that suspension was, my lord,
No, page number.
page 28, my lord.
Yeah.
Now, after that, my lord, revoking the suspension, he has not been allowed to join, not allowed any work.
16/9/2024 order, Lordship. 16/9/2024.
They cannot do it, my lord. This is in violation of Ajay Chaudhary's judgment, my lord. They have not filed any affidavit. They are not filing any
Honorable
affidavit.
Justice Suman Sharma order, Lordship. 16/9/2024, Lordship.
What is that order? Yeah.
Lordship, may I read, Lordship? Third line, Lordship. Respondents who submits that since the earlier order of suspension was issued by an authority not competent under the law to do so, Executive Engineer PWD Dokmoka Roads Division, hence the Deputy Secretary PWD KAC Diku has issued a fresh order of suspension dated 19/3/2024, placing the petitioner under suspension after revocation of the earlier order of suspension by order dated 18/3/2024. Mr. So-and-so further submits that a departmental proceeding has already been initiated against the writ petitioner and an inquiry office has also been appointed. Thereafter, Lordship, in the fourth para, in view of the above, on the request of Mr. So-and-so, this matter stands adjourned for 2 weeks as so to enable him to obtain instructions. And we were also asked to file an affidavit. Thereof, Lordship, present status is not known to us.
Second suspension order.
Suspension order that we'll bring by way of an affidavit, Lordship. It is there. We'll bring it by way of an affidavit. Some time may be granted, Lordship.
Whether any new materials are collected in the
Lordship,
or something that
Lordship, 20 March, show cause notice was issued, Lordship.
order after revocation of the first suspension order,
Lordship.
whether material is collected against
Lordship, present status is not known to us, Lordship. That's why we want to take some time to file our affidavit and take instructions as well, Lord.
We have not been served with anything, any order, my lord, of further suspension or, my lord, disciplinary proceeding, nothing, my lord. And they are withholding this affidavit for the last 1.5 years, my lord. 2 weeks time was granted to them to file the affidavit. They have not filed it for more than, my lord, a year now. And they still want time, my lord, Lordship. People will not.
Last week, Lordship will file it, Lordship. Lordship may kindly
They are
grant
keeping
us
this
some
matter, my
time.
lord, pending, my lord, just for the, my lord, sake of keep it pending, my
you
lord.
see, letter was the last date on 16/9/20.
22. Thereafter, now only it has come. It has been listed today, Lord.
You pay some cost, will grant you time.
Lordship, last chance may be granted.
No. What
1 week, Lordship. 10 days.
hurt the end also hurt. Right?
Respond number 2 and 4.
One.
And that's for 3 and 4.
Yeah.
3 months. 2 and I have 3 months.
It's separate from that. It granted time by the evidence. But it appears that by order date 2024, the respondent KA authority that it is being there on record by not by them. It is accordingly allowed subject, however, to pay the possible then welfare fund.
Lordship, show cause notice is here with me, Lordship. Kindly, Lordship may see. Lordship, cause.
Before next step, you have the fund.
Well, may I prefer a date, madam? May I prefer a fixed date? May I prefer a fixed date, madam? Any date convenient? 13th of. Keep the place.
May I please? In this case, my lord, the issue is either microbiology, MSc in microbiology is equivalent to, my lord, MSc in zoology. For the for the appointment of the post of postgraduate teacher in zoology department. My lord, in this regard, my lord, this is second round of litigation. UGC is state department has filed the affidavit, my lord, filed the reply. UGC is the authority, my lord, to give the affidavit, my lord. They have not filed yet, and their notifications are there. We may proceed with their notifications.
No, your lordship, we are yet to receive the instruction, requisite instruction. We have sent our copies. Yes, your lord.
They have taken time to.
If the notification are on the record, then why? Then are
Yes, your lordship, but for the filing of a counter affidavit or our sons, we have to follow our instruction, your lord.
My lord, this
notice on long back.
Yes, your lordship.
Why not record?
Lordship, we have sent the copies to the department long back, but some delays or.
Notice on 30.
Yes, your lord.
in fact, the petitioner has been appointed, but my lord, after the appointment at the time of her joining, it was kept on event. Having come to know that they have no, and she is from microbiology, my lord. Already after verification, everything has been done. She has been appointed, duly appointed, my lord, and thereafter she has been her appointment is kept on event. And my lord, in fact, the candidates from biotechnology department and other department, my lord, they have been, my lord, appointed. The state respondents, my lord, in respect of biotechnology department has taken a view that it is applicable. But the present position is that, my lord, the life science is a vast subject. It covers around 16 subjects, my lord. UGC has given the criteria for net qualification, and the Guwahati University in the state of Assam, my lord, has set examination. They have prescribed their syllabus, and all the syllabus, my lord, contains that the life science includes around 16 life science subjects, biological subjects, or 16 subjects. And for them, the common net examination, common set examination. Therefore, my lord, all these subjects have the equivalency and they are related. And the Assam University, Silchar, my lord, in this respect has also given their opinion, expert opinion comprising of 5 professors of the university, comprising of microbiology department and the zoology department and other life science department. They have given their opinion that the for the purpose of teaching in the higher secondary level, the syllabus and course which are taught in microbiology also cover, and they are equivalent. They are eligible to be appointed. And my lord, the UGC guidelines with regard to relevant subjects, my lord, it includes for NET and SET examination the all biological subjects, and for the purpose of teaching in the assistant professor level in the colleges and universities, my lord, that the UGC regulations are also are applicable, and that includes, my lord, all these subjects. And you are taking the NET examination not for zoology, not for botany. You are taking the NET examination, SET examination for life science subjects altogether. Only one examination for all categories of life science subjects. But while appointing, my lord, you are creating the discrimination in respect of the state of Assam in the education department. And whereas the pursuant to the direction of this honorable court, the expert committee convened a meeting in respect of biotechnology subject, my lord, and they have decided to include the biotechnology in respect of both zoology and botany department. But why, my lord, discrimination to the other subjects, my lord, whereas the expert has given the opinion also? And here in this case, my lord, we have put to challenge the impugned opinion given by the assistant professor. They have in the education department, they have convened a committee over online discussion with in the committee. The commissioner was there and 2 assistant professors of B. Borua College. the lowest level in the teaching level, my lord. They have taken their opinion. Only they belong to only botany subjects, not zoology subjects, and not from the microbiology department. It has to be done. If they at all desire to take the opinion of the experts, my lord, they have to take the opinion of the experts who are teaching in the university level, instead of taking the opinion of experts. Well, instead of placing the matter before the experts, the commissioner over telephone or in the online mode, my lord, he has taken the opinion, and they have stated that they know these are not microbiology is not covered by the zoology, and therefore I cannot be appointed. They are whether they are expert. As per the Supreme Court guideline, my Supreme Court instruction, UGC is the only expert body in this regard, and UGC in their regulation has prescribed the net qualification. Yes, sir. Yes, sir. Yes.
One and two are allowed.
Allow for
This few party for respondent for your lordship.
Wayan Mohanto, your lordship. 5.
And 25. Type by for 5. Right, for granting there allow something and also for the high court. For the employee accounts fund.
Well, a date may give me. Yes. Yes, started, my lord. Obliged.
That in this case, as a respondent number 7, we have filed affidavit. That is not in the record.
Let us not be in document matter extremely urgent matter because they have been taking time and differently.
No.
Let me submit. Don't argue now. Hello, one after another. There are number of Saitya Sabha they are bringing in. We don't know. Whatever matter here, there is a dispute regarding the grammar of Mr. Manipuri language. Now, the students, my lord, under the Right to Education Act 2009, they are entitled to study, my lord, in their own mother tongue. Because of the dispute between two or three organizations, the SCRT is not, the government is not in position to decide what is what. They have invited, they would not attend. Somebody will not attend. Ultimately, this IMA means mother organization, race organization, is before lordships for directing the SCRT or the government to constitute an expert committee of the Indo and Aryan languages. So that the dispute on the grammar can be finally decided and the students are given the facility to study in their own mother tongue as per the 2009 Act. So a delay, last 2 years, they were deprived. They could not study.
Yes, last occasion, we have been implemented as the respondent number 7. On Friday, that is on 29/8, we have filed affidavit in opposition. That is not in the record. That's why in the morning also I wanted to mention, but I could not. I have come late.
Because any delay is also they will lose.
Friday may be taken matter. Friday, it's Friday. Because Wednesday, Friday may be taken.
No. Tomorrow let the order be there to call the maybe tomorrow Friday I'll be out. So
tomorrow then, tomorrow I am ready.
Yes, tomorrow let me
Tomorrow I am ready.
maximum are the mileage. This year also they will be losing for fighting of the infighting of the leaders.
Okay. Let it be tomorrow
Tomorrow, yes.
at 2 p.m. then.
And
Tomorrow at
2 p.m. to 2 p.m. at 2 p.m.
Third- third- third-
Respondent 7. Respondent 7. man.
then
Respondent
not
five.
for respondent,
Five.
and for one and one. By
My
10
lord,
for-
age bureau for respondent number 4, my lord, SCRT.
by 10.
Five.
By by yesterday.
No, my lord, Friday, my lord, on
Friday.
29/8.
Not that- that- 46. Take the method to at PM, and after take the right for the
How is it, ma'am?
Problem.
the applicant. So this matter is relating to non-payment of gratuity and final bench. And the petitioner was serving as district elementary education officer. He retired from service on 30 September 2019. But gratuity lordship has not been released on the ground that during my service period, certain period lordship, I was on deputation. And that period lordship has not been regularized. That lordship petitioner, he has got salary, everything. We have no grievances on that. That period lordship is to be regularized. That period has not been regularized. They have filed an affidavit saying that since it was beyond the period of 5 years, it will be approved by the cabinet and it will be placed by the cabinet. But till date, lordship, they have not placed anything. Lordship, if you lordship kindly come to page, running page in their affidavit, paragraph 6 and 7. 43, page 43, their affidavit. This affidavit was filed on 11 June 2025. More than 6 years, lordship, he has retired from service. In fact, several proposal lordship during his service period was placed before the government by the mission director for regularization of his service.
Ahora, iba po SSA.
Well, I'm for SSA. Whether it's the government will take the call. Well, he said,
Went to regularization.
yes, the government had to take, the education department had to take the call.
Which agent for government?
Well,
Which agent for government?
education department, school education is there. Well, lordship page number 35 will make it clear, my lord.
For
35.
Secondary, elementary, secondary.
Thank you.
Yes.
The Deputy Secretary to Government of Assam Secondary Education Department had written letter to the Deputy Secretary Elementary Education to regularize whether this period can be regularized. Ultimately, they need to take a call.
Prior to that, lordship, page 26, that proposal was also placed by the mission director in the year 2008 also, while I was in deputation.
Whether for deputation, current from the finance department is required.
OM, their requirement is for 5 years. The person has lost 5 years. For that, lordship, as per our OM, he is not entitled.
No, who is responsible for that?
Lordship, So now a cabinet decision will be required, and that is to be by the government, the Department of School Education. This affidavit, an affidavit has been filed. We have been given a copy by respondent number 1. There they have stated that, and in the affidavit, they have also stated that they are in the process of placing the same in front of the state cabinet.
When?
Lordship was called for that was called for on the last date.
Earlier several dates, Lordship. Last provision also. That is
last query was raised by.
Yes, who is appearing for school education department? You are appearing, but you do not know anything regarding the case file.
Lordship, I have not been allotted today, Your Lordship, so I'm not aware of the case, Your Lordship.
Who has been allotted?
It was allotted to D. Mushahari, Your Lordship, but due to some personal difficulties, she has left the court today, Your Lordship. A child was sick, Your Lordship.
on the last occasion also same thing was happened. Another council was appeared. He, that's Lordship, I think on the last day.
The process.
Affidavit has been filed, Your Lordship, by D. Mushahari.
That affidavit is filed in the month of June, 11/6/2025. That matter will be placed before the cabinet.
Why the matter is not placed with the cabinet? And
I'll get the instructions by the next day, Your Lordship.
Next date in this.
tomorrow then?
Yes, Your Lordship.
Friday then? Friday. Thursday and there are or
Well, from number 6 and 7. Same thing.
we have for number
I'm appearing.
for number 5. There are so there was the direct of the in respect of the observation made in the paragraph for the counter on the department. Yes. The meter was earlier allotted the left the rest of Friday.
Yes, sir.
They provided the right in the name of the part of this, and further it is provided that there are the respect of the observed the counter. This record.
Lordship, I, on behalf of Mr. M. Hussain, respondent number 4, due to personal difficulty, he could not attend the court. May kindly please come after 1 week.
Lordship, we have some urgency, Lordship, and they are trying to delay it because they are the private respondent in this matter, Lordship. We have some time constraint, Lordship. Lordship,
When do you want?
Next week, any date.
Lordship, Friday, Lordship, day after tomorrow, Lordship. We have some urgency, Lordship. Because they are
Friday.
Friday, day after tomorrow, Lordship. Lordship, Friday, Lordship. The more the delay, Lordship, we are in good luck, Lordship, in loss.
Lordship, Monday, 8.
Lordship, Friday. We are coming today, Friday then.
Friday.
Yes, Lordship.
Right.
27.
That is your lordship. My lord, 27 and 29 may be taken together, my lord. Same issue, just my lord, two sets of petitioners, my lord.
Lordship, in 28 lordship, I have to file my response lordship.
29, 29.
Yes, it's 29.
29.
Yes, 29.
My lord, in the meantime, my lord, what happened, my lord? Kindly turn to page, my lord, 53 of my lord, the first item 27, my lord. The special police recruitment board state level, my lord, made an advertisement on 6/10/23 for recruiting some 5563 number of posts for constables, my lord, in different categorized. Accordingly, we have applied. Many have applied. We have passed, my lord, PST test, PET test, medical test, my lord. We have crossed it. After crossing the same, my lord.
Your professor that both the matter be heard together.
Yes, ma'am. Because same issue,
File
ma'am.
his affidavit
Yeah,
in
lordship,
item number
lordship.
29.
My lord, my lord, the affidavit is already filed in,
No, no, in
other-
29 lordship,
My lord.
in 29, I'm not filing the.
My lord, everything is as it is equal, my lord, except the marks, my lord.
Both the action are separate lordship.
Everything is same.
But matter, same advertisement, same selection, but different candidate. Lord.
Candidate is different only.
Yes.
That's different.
Different
Everything is,
candidate and different marks.
my lord, issue is common. My lord, issue is my lord. I would not have any objection for taking time. It is even good, better for filing, my lord. But what happened, my lord? They are going to appoint, my lord, shortly. And once the appointment is done, my lord, we will be, my lord, in problem, my lord. We have to make them part in the all thousand.
Shortly,
My lord,
shortly means,
short, my lord.
shortly means when?
My lord, within 10 to 15 days, my lord, they are going to appoint. My lord, that is confirmed. That's why, because we were not hurrying, my lord, because we were given an assurance verbally that it will be considered, our case will be considered. That's why we are not hurrying. But now they are not saying so, my lord. That's why,
Okay, 1 week time
Lordship.
after one. Let's find that.
my lord, my learned word is only just to repeat the same, nothing to perhaps only to repeat the same.
Candidate, different candidate.
Only delaying issue,
different
my
marks,
lord.
Lord.
Issue is only delaying, my
No,
lord.
no.
Otherwise, I could have been happy, my lord,
1 week, Lord.
by filing.
No, Lordship. Additional senior government here in this case. Lord. On behalf of the respondents, Lordship. All the respondents.
So the item number date or by
29, my lord.
and
29.
price draft. File.
My lord, kindly short, otherwise they will appoint, my lord. We will be in Noya, my lord. My lord, May 11th, my lord. May 11th, my lord. It will be, my lord, 11.
11, today is 3.
My lord, both the cases can be listed together, my lord, but kindly mention.
What is the
May it please your lordship, matter pertains to pension of the dependent daughter, divorce dependent daughter, lordship. Actually, petitioner's father was a inspector in the CID, lordship, and after his retirement, he was a pensioner. After his retirement, he was a pensioner, and his after his death, his petitioner mother was a pensioner, and petitioner got entered into marriage on 1/12/2002, lordship, and thereafter she got divorced from her husband. I have annexed the judgment, lordship, annex of 5 on 11/1/2013, lordship. She returned back to her maternal home, lordship, and till then she is dependent on her mother. So mother was a pensioner of her father, lordship, and her mother, Gauri Roy Chaudhary, died on 2/4/2024, lordship. As such, she approached the CID for pension, lordship, family pension, but initially they have they have not accepted it. We approached with representation, lordship. Representation in Annexure 8, lordship. Page 36, lordship.
Yes.
Yes, Lordship. Third para, Lordship.
You have filed your affidavit.
Yes, Lordship.
Yes, Lord.
What is your stand?
Lordship, paragraphs,
Seven.
paragraphs 6, Lordship, page 52, Lordship, relevant portion. Relevant portion is page 52. Lord, it starts from 51, Lordship.
Sir,
Lord.
if they file along with the court certificate,
Yes, Lord.
and if you prove that act
Yes.
a position considered.
Lordship, because Lordship, although we in our pension rule, Lordship, it is not regarding the divorcee. There is no provision, but subsequently, Lordship, though the judgment of the Supreme Court, Honorable Supreme Court, as well as our High Court, Lordship, now it is settled, Lordship, and therefore
I've annexed
they
the
have to
judgment,
file
Lordship,
all these things.
in Annexure 10, Lordship. The High Court judgment, Lordship. Page 43, Lordship.
Be- Before sending the proposal, Lordship, before sending the proposal, these documents is required, Lordship. She was not filed, Lordship.
I'm ready to, Lordship, but AG's Lordship, AG's instruction is required because AG has sent us a letter. Lordship, it is not legible clearly, but to the petitioner, Lordship, during the pendency of the petition, Lordship.
Yes, Lord. AG.
RK Talukdar
RK
was,
Talukdar.
Lordship.
He is there. Can you read this? Do you have what public?
In the reported case, Lordship, AG was also a party, Lordship. So that's why.
Sometimes
Yes, yes.
then in fact it depends upon the department.
Yes,
Because
Lord.
the department
Yes, Lord. From the department, Lord. Yes. Before to send the proposal, preparing the proposal, Lord. These documents is required, Lord. And
We will be allowed to,
one
Lord.
Lord.
directly to her
Lordship, representation, Lordship.
and the main
Can it
file the relevant
relevant document, and we will prepare her proposal, and thereafter we send to the authority, Lordship. That's
AG will consider, Lordship, kindly that portion maybe make sure, because Lordship, in the Hasiba Begum case, AG was also party, but they are saying that Kanji Devi, yes, I have Lordship.
yes, Lordship. The divorcee in some conditions given, Lordship, but divorcee is
He is
treated as
entitled.
the entitled, Lordship.
Yes, Lord.
Entitlement is there, Lordship.
Yes, Lordship.
Unmarried, the definition of unmarried daughter, Lordship. After divorce, Lordship, marital status gone, Lordship.
the Haryana High Court.
Oh, Lordship. Yes, Lordship, I have that.
এইটো দিতে হ'ব।
It is marked.
Please, Lordship. Lordship, I'm appearing for respondent number 226, Lordship. Need some time to file affidavit.
If I may submit, your lordship, actually, in this case, the notice has been issued on 13/6/2025. On that day, the respondent authorities were present. Thereafter, your lordship, they took another date in the month of August. Now they are taking another date, your lordship. The issue here is that I am being victimized. There is a series of malafide and they are just buying time, your lordship. It is just continuing again and again. So and I am victimized out here. I was supposed to become supposed to be promoted to the deputy general manager marketing. Now to stop that promotion, they are undertaking all these activities only to prejudice me so that I do not get that post, your lordship. If your lordship can, even if they're asking for time, lordship can give a very short date, maybe next week we can just go ahead, because my club, I am suffering here, lordship. We are just waiting for them to come and respond, and they are just taking time again and again. Every time they come here, they say,
In the first occasion, physically appear.
My lord, I am appeared in the first occasion and second occasion also. And after appearing the first occasion, my lord, I have communicated later to the respondent authority with a copy of the petition. And they also contacted me, but after next date, my lord, they informed me that they have a standing council. He will appear. And today is appearing. My lord.
but on the last occasion, he did not appear, although he mentioned that he will.
I didn't have the workload number.
How?
Okay, you file your
Yes, 2 weeks time.
1 week, your lordship. We have waited already. 8-9 weeks have been given. 3 months have been given, your lordship.
We need to seek instruction, lordship. At least it will come from Namrud.
Already.
Okay, 2 weeks time maybe. Then.
What the hard is?
P. Barwa, your lordship.
2 to 6, lord.
After 1 week.
Yes, much obliged. Lordship has an interim order, if that may continue, your lordship. Much obliged, your lordship.
In this matter, your lordship asks for instruction, my lord.
Yes.
And yesterday evening, I received one communication from the director, my lord. Director had written to the district elementary education regarding the sending of test proposal, my lord. And district elementary education, my lord, took time for 1 day because my lord, today is a government holiday, my lord. So he kindly schedule the. So in fact, my lord, I personally telephonic receive telephone process is going on, my lord. Like he will regularize in the meantime, my lord. So
Now, why test proposal is required?
my lord, earlier, my lord, some instruction received by the director, my lord, but the test proposal and some document not sent to the director, my lord. That's why, my lord, again ask for the but DO written to the director that as today is government holiday, my lord, he could not maybe tomorrow he will send a
Proposal.
proposal, my lord. So may I pray that, my lord?
Shift only is nothing left, only the director to pass an order. So kindly, he said 1 day. Kindly fix the matter on Friday.
If he is in hurry, my lord, then nothing will happen, my lord, because I pay.
1991. I'm on the verge of my poverty. Shift.
Is the office of the director. Proposal is yet to be submitted. So, one or nothing happened. After the vacation,
My lord,
So prior to that,
that will be better, my lord, because in the meantime, everything will clear, my lord.
before vacation, lordship. Otherwise, they will keep on taking time and time. Otherwise,
or they was
হ'বই তাৰমানে কালি মোৰ কথা আহিছিল পাৰ্চনেলি কথা পাতিছোঁ তেওঁলোকে ইমান হেৰি কৰিলে নহয়
ordered one of the on account of holiday. You want to take it?
Yes.
Over the direct. After we
Obligement.
Last question, lordship, one record was called for. In this case, petitioner is behind.
Mr. Kyal is on legs on court number 18. Lordship. Yes, yes, sure.
Yes, my lord, petitioner is retired from service, my lord. And the last occasion I pray before lordship for implemented a new contemner, my lord. But she is not, my lord, I am already prepared for implement petition. I think, my lord, time and last chance were given. Otherwise, my lord. There is a specific order from the Honorable Court for releasing the salary within time frame. In the meantime, after during the pendency of the contempt petition, he was getting it as a tutor appointment. Tutor appointment was taken. And thereafter, she was going to, 3-4 months, she is going to retire. So, my lord, without challenging that tutor, I think that is also some, at least 2 weeks time maybe allowed. I mean,
sorry, order. Order press for file application. There is a after
much.
Similar submission because the petitioner says, my lord, I have heard, my lord, but no documents I have received, my lord. They were accommodated as tutor, my lord. That instruction, my lord, I get, my lord.
Elementary to
how many petitioners were there?
My lord, here 5.
Accommodated as tutor. As per his comment, but
After vacation, my lord.
After
Obliged.
It is the motion. So the 2016 contempt matter and the order violation which has been alleged is dated 11/6/2015, my lord. On several occasions, due to non-compliance, I had to implement new party respondent, and I fear that, my lord, this time also the same thing will happen, my lord. It's a fit case for issuing contempt notice, my lord. The relevant paragraph of the judgment, lordship will find at page 12, my lord. They were supposed to revisit, my lord, the entire exercise of calculating the pension amount. Page 12, the last paragraph 9. Nothing has been done till date. It's been around 10 years now. In fact, more than 10 years.
Lordship, I am for respondent number 7, your lordship. Lordship, the communication that has been made to me is that we had not received any sort of no has requested Director of Secondary Education as well as the concerned petitioner to provide the required records documents to the concerned HOD to this head of office to this director for taking further needful action as per direction of the Honorable Court. But in this regards, no reply has been received by this directorate from the concerned authority till date. So it may be stated that necessary action towards disposal of the matter will be taken on receipt of the required documents, records from the competent authority at the earliest as per rule, your lordship. Way back in the 2024 it was. So if the council representing the department, they comes with
Fit case, my lord, for issue of contempt notice. Let the contempt notice be issued against the respondent number 8. Otherwise, they will not act, my lord. Director of Secondary Education.
Secondary Polytechnic. Yes, sir. Secondary Polytechnic. Good. Petition to DTO.
Hometown user.
We have data server. একটু আমাদের মেটাটা বুঝলেন তো কখন আপডেট কি হয়েছে Yes, Lordship kindly give me a week time. I will get a up-to-date instruction along with everything, Lordship, by next date, Lord. By Monday, I think you are. Good, sir. Right, Monday. Any day next week, Lordship. I'm copy to the kindly. Era copy. Yes. 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 Yes, Your Honor. Yes. 16 matters. Yes, Lordship. Yes, I have seen.
And one month, about 1 month back, there was a new things that the Department of School Education has the highest number of contempt
Yes,
in
Your
the
Honor.
country.
May I please, Mother, this is also 2016 contempt, my lord. Operating part is, my lord, page 9.
Look, no problem.
Yes.
If it would have it. But here, though it is a 2016 matter, Lordship, the respondent 1 retired long back and 2 has already been expired, Lordship. Whether the present incumbent, they were informed about this pendency of this contempt petition, only petitioner may, Lordship, can explain. Because I have seen earlier counsel, they were appearing on behalf of the earlier respondent, Lordship, where respondent 2 has already been expired.
My lord. Casing, my lord.
for a department loss may kindly.
What?
1 and 2 loss for a elementary department loss. One retired long back.
Yeah.
Expired.
Property. By weeks.
Item 36, my lord, we have filed a review and corrected affidavit also we have filed, my lord. But today, my lord, learned counsel for the petitioner, he has some difficulty. In fact, he called me up.
Requested us.
He called me up.
Yes.
He has some physically.
Okay. Review petition filed.
We have filed, my lord. In fact, we have mentioned in the affidavit that we have filed.
Not for the
It has not been numbered, my lord. We have just filed on same day, my lord. When we have filed the affidavit, on that day we have filed a review. On 28.
28. 28.
28.
file and get recording it is provided that after day after.
Yes, no. Apply.
Judge.
May it please the Lordship. Lordship, page 16 is the Honorable Court's order dated 9/2/2024, page 16, my lord. Now relevant portion, my lord, page 20, paragraph 12. The state level scrutiny committee, upon consideration of the case of the petitioner in the light of the recommendations made by the district level scrutiny committee, proceed to recommend case of the petitioner for provincialization of service. The Director of Elementary Education Assam shall take appropriate steps for implementing such.
My lord, here are some steps we are taking, my lord. Here, department seeking a clarification from the senior standing council. So matter may come up on Monday, my lord. Now, my lord.
We've been asked to
Order the steps taken by the department, my lord.
file an affidavit indicating the step you have taken.
Here, true, my lord. We have filed our affidavit, my lord. Here, his case was placed before the SLC. My lord, kindly see paragraph.
When you have filed it?
My lord. That, my lord, I have not stated here in my affidavit. 28/8, my lord. Only thing is that, my lord, some process is on, my lord. My lord, we are seeking some clarification from the senior standing council.
My lord.
On Monday, my lord.
My lord, kindly peruse order 6/8/25. Here says, my lord, he has to 1.5 year is gone by. So he has to.
No, whether you have filed your affidavit here or not.
Well, we have filed. They have filed. Very surprising, my lord, affidavit. On 28/8, I have received copy. Here says that, my lord, I have fulfilled eligible criteria. In the meantime, the government had taken a decision that provincialization was one-time measure to be provincialized. Very surprising, my lord. Provincialization is not one-time measure. How is it, my lord? He has asked to indicate each and every step taken since last 1.5 years. Nothing has been mentioned, my lord. It is, my lord, only taking something, filing something, delay the matter, my lord. This is the mockery with the court, my lord. Finally, my lord, so now the time has come, my lord, to take some necessary steps, my lord. It is mockery with the court. Court has directed You have to explain what you have done, what you have taken steps since last 1.5 years. Nothing here. Only even they have said that it is a one-time measure. How it is one-time measure? Where is it, my lord? We are, I have a right under the act to be provincialized social science teacher, my lord. I am depriving from statutory right. They are saying one-time measure, and nothing has been reflected in the affidavit what he has done since last 1.5 years. So, my lord, it is right time, my lord. Otherwise, so many contents, my lord. I personally appear so many cases. Cases I am also appearing since 2022. No compliance, my lord.
Seeking, well, we are department seeking some clarification from the senior standing council regarding his appointment, ma'am, as a tutor.
My lord, my what clarification is act? I am under the act. My right
My
is
lord,
under the
my
act.
lord,
What
some-
clarification request from standing council? Standing council is not above the act, my lord.
Interdepartmental communication, these are, my lord, my lord.
Monday, my lord, with explanation what he has done in last 1.5 year in terms of honorable court order 6/8/2025.
Well,
I'm
obliged.
May it please your lordship. Lordship, as per order dated 14th. As per order dated 14th of September 2025, lordship. Lordship, I may be allowed to take dusty service upon respondents number 3 and 4, lordship.
You have taken
Lordship, I had taken steps earlier, lordship. Till now, acknowledgement card has not been received back, lordship.
that's it, sir.
Dusty, no, lordship. We haven't taken dusty, lordship. We would like to take dusty, lordship. No, normal service had already been taken place long back, lordship, but they have not received, lordship. As
Or-
oh,
or- they they all check are by the
no.
get out of by how much responsibility there.
Lordship, 1, 2, 3, and 4, and 1 and 2 is
I am for
represented
1 and 2, Lords.
by the government.
But 3 and 4.
Yes, lordship. Yes.
This
Okay.
after 1 week,
Yes,
1
lordship.
week.
Lordship, 2 weeks, lordship. Deeply appreciate.
May I please your lordship? We were supposed to file a affidavit in reply, but since last six occasions, we have been unable to contact the petitioner. It's almost a year now.
So when can it be listed?
Lordship, lordship may dismiss the case.
This interlocutory application for what purpose?
Non-payment of the salary of for the month of
Interlocutory application.
March 2023.
So both the method, I and the main petitioner. Your name is not in the complaint.
No, Lordship. I'm appearing on behalf of Mr. N.J. Gogoi.
Is present in the court.
He's in some other court.
Can you ask him? Court?
Lordship. But in this case, my lord, I have had an affidavit in reply, my lord, to the affidavit opposition filed by the Peaceful University today, my lord. So, matter may come up along with the affidavit in reply, my lord.
May I please, Your Lordship, I'm appearing for respondent number 6. We have already prepared an affidavit, my lord. 10 days time may be given and date may be fixed, my lord.
After
A date may be fixed, sir.
I'm appealing for statutory inversion. Respondent number 1 to
1 and 2.
1 to 4.
My lord, obliged.
On last occasion directed me to open certificate copy. I have opened certificate copy. These are the copy of the
Petitioner behind the bar more than 3 years, 2 months, Lordship. Our only quantity is only 289 grams. So this is a quantity of the seized articles, Lordship, 289 grams only. Commercial, that
It
is
is not commercial.
commercial quantity, but not higher commercial, Lordship. 289 grams are with more than
How you could satisfy the
Lordship.
requirement of section
3 years.
37?
I am on the ground, Lordship, 3 years, 2 months already behind the bar. Only 2 witnesses examined till today, Lordship. Though earlier 2 occasions, your Lordship was directed to the learned trial court to expedite the trial.
Interestingly, the PW2, it rows may be seen. Admittedly, the entire case has been admitted by the entire case has been proved that they are convicted. They will be convicted. The way he was cross-examined, everything was that he just committed the offense. Now, the day before yesterday, Delhi High Court has passed an order in case of Pradyumal Ilan. If the copy is not with me, I'm reading 2 lines. While denying the bail to Omar Khalid, Jil Imam and others in Delhi at large that conspiracy case, the Delhi High Court observed that trial need only progress naturally. The hurried trial will detrimental both to the accused and the state.
This is a different issue, Lordship. This is a Imam case is a different issue, Lordship. This is not a fact.
This is more serious
in this
nature.
regard, Lordship.
DPS.
Regarding the delay of the trial, embargo of the section 39, relying some judgments of the Honorable Apex Court as well as the dishonorable courts also, Lordship. 3 judgments is there. More than 3 years already custody. Another prayer is that, Lordship, she has a minor daughter. There is no family members except her father and mother, Lordship, of the petitioner. They are old ages and they are residing in the More district of Manipur, Lordship. Look after for her minor child, 11 years child, one daughter is there, Lordship. Only these 2 ground, Lordship. I am not on merit, whatever it outcome in the trial, Lordship, she will face with any condition, Lordship, any condition. Only for her daughter in the present situation. One minor daughter is facing some disease, Lordship, though we have tried to collect some medical document, but she is residing in the More district. Her grandmother, she is residing with her grandmother. She is also not possible to better treatment her in this situation. Some violence area they are residing in the Manipur. As far as they have informed me that with any condition, Lordship, He will face trial, Lordship.
Or, uh, or-
With any condition, Lord. Oblige, your Lord.
Made vigilance. Lordship, last copy on instruction was sought for from the respondent.
your prayer was rejected.
Lordship, my
Secretary, man. Sole respondent.
solo page number 14, Lordship, direction was to verify the matter. And if I was found in stability, then my pension may be allowed as per all pension scheme, Lordship. But till today, sir, no reason order has been passed. No communication was issued to me regarding my
Para 6 of the order. Tutor, man.
no, Lordship. Uh, I was retired before, Lordship, in the year 19. In 2020, a similar situated Lordship, STEM teachers were accommodated as tutor or assistant teachers. But Lordship, I was retired before the said.
But he has participated in the screening process, my lord. Petitioner has participated. He is fall under category 1, my lord, the teacher who have received salary up to 2007 onward and having, well, as per my lord, report, my lord. As per my speak.
No, Lordship.
Now he have to challenge this order, this is speaking order, my lord. Because here order was passed, my lord. Accordingly, this court
Lordship,
disposed of the
till today,
petition.
no speaking order was communicated to me, Lordship.
But that was marked to him, my lord, in the year 2024 itself, my lord.
Order was passed. Artifact of
My lord, I'll finish him.
passed about 1 year back.
My lord, true, my lord. But definitely I'll finish right now.
Artifact,
Jai Hatimuria.
Sole respondent, my lord.
order. Well, order for part A. Thank you.
Obliged, my lord.
As per office note dated 29/8/20, service report is awaited, Lordship.
If it are of- it- it- Dr. Big-
Please, your lordship. I have filed a recalling application. In this case, your lordship, the respondent number 4, agency franchise development, that is a French development agency. We are working like sanctioning the funds to the state of Assam for the development of the project on various sectors, your lordship. We have no role to play. Without any, your lordship, without any requirement, we have been added as a party respondent, your lordship. So I have filed an applications to delete our names from the arrays of the party respondents. We are neither the necessary party nor the proper party. There was an agreement between the forest department and the petitioners. We are the one who funds, just like Asian Development Bank, International Monetary Funds. We are also an agency who funds, your lordship, for any development project, which is non-refundable. Now, this fund was sanctioned by us for the development of the forest areas in the state of Assam, for carrying out the various forest activities, for the protection of the environment and all those things. Now, there was an agreement between the forest department and the petitioners. The forest department, for some reasons, has terminated his contract. Now, initially, when he filed the writ petition, we are not added as a party respondent. We are based in France, your lordship. Now, subsequently, by implement application, we have been added as a party respondent. And he could not show any reasons as to why we are required to be added as a party respondent. So my humble prayer before your lordship is that we may be deleted from the list of the party respondents, your lordship.
Yes, my lord, I have filed my objection, my lord. I think it is a requisition, my lord, came on record.
तुम्हारा implement application तो है.
Whether you have claimed any relief against
Though no relief is claimed, but it is a necessary party because my lord kindly come to the appointment letter. Appointment letter, my lord, page number 28. My friend has wrongly submitted that the agreement was with the forest department. It is not forest department, it is with the project PD. The project is called, my lord, Assam project on forest, my lord, page number 28. Page number 20, my lord. It is, yes, main petition, my lord. Main petition, my lord. It is a with the, my lord, Assam project on forest and biodiversity conservation society. It is not forest department, my lord. 28. The appointment letter is issued by the project director, my lord, of the project, my lord. And project is financed by the, my lord, this respondent, my lord. Only finance, and the salary is, my lord, paid from the finance of this, my lord, respondent number 4, my lord. I have annexed the in the agreement clause 8 is mentioned, my lord, clearly mentioned. Page number 28, my lord, kindly see, my lord.
Yes.
Is the appointment letter, my lord. In the left side, my lord, it is the name of the respondent mentioned in the appointment letter itself, my lord. AFD. AFD is the respondent number 4, my lord. In the left side top corner of the appointment letter, my lord. And my lord, in that it is mentioned by the project management unit, Assam Project Forest and Biodiversity Conservation Society. So this, what we implement this, my lord, project, this society is for, my lord. It has no connection with the forest department, my lord. Though the PD is the principal chief conservator, my lord, of the forest department, my lord. This issued by the, my lord, project director, my lord, project director PMU APFBC society. And this society is formed, my lord, only to implement this project, my lord. Now, my lord, your lordship, I am to the page number 19, my lord. Page number 19 is my agreement, my lord. Page number 19 and relevant page is 20, my lord, 20. 20 clause 8, my lord. Clause 8, kindly, my lord. We understand and hereby agree that remuneration so and so only
Page number?
page number 20 of my read, my lord.
Right.
Read petition, my lord.
20.
20, my lord. Clause 8, my lord. This is the agreement start from page number 19, 19.
Yeah.
So clause 8, page number 20, my lord. We understand and hereby agree that remuneration so and so only per month inclusive so and so shall be paid by the APFBCS. It is not the forest department, my lord. It is not paid by the state government, my lord. It is only by this society, my lord, which is formed to implement this project, my lord. And this project is going on, my lord. Unless the fund is provided, my lord, this project will not continue, my lord. So page number 18, your lordship will find here also, my lord, this in the letter, my lord, this respondent number 4 is mentioned, my lord, in the letter also. And this project director, my lord, is the my signing authority. He has signed on behalf of this, my lord, a society which is formed for the. So it is required, my lord, because whether the fund is coming, my lord, whether the project is going on, what is the time, everything will depend on their responses.
Oh, it's for
Yes, your lordship. May I just explain, your lordship, the position is like this. We provide, we have given a funding to the state of Assam or the forest department to carry out something. They are doing the work. They have entered into an agreement with somebody, anybody it may be. How we became liable? What is our role?
you may not be a necessary party, but maybe a proper party.
No, we are not even a proper party, your lordship. There is a Delhi High Court judgment division bench. Bang on that target, your lordship.
Pardon?
If there is a Delhi High Court judgment division bench, an agency which funds is neither a necessary party nor a proper party, and he cannot be arrayed as a party respondent. If I may please, your lordship, will kindly see page 18. This is a case. It's a government of Assam, your lordship. In the letterhead, it's written Government of Assam Project Management Unit, Assam Project on Forest and Biodiversity Conservation. I'll just place it before your lordship. I'll give him, your lordship. If I may just read the relevant portion, your lord.
Okay.
No, I'm not reading the soft copy of the detail. If your lordship comes to para 1, has your lordship got it? Central government floated a scheme in the year 1975 known as Integrated Child Development Scheme, hereinafter referred to as ICDS. The object of the scheme was integrated delivery of certain services as supplementary nutrition, immunization, health checkup, referral services, non-formal education to preschool. Now I'll skip all this line. The scheme was funded, the third line from below, your lordship. Has your lordship got it? The scheme was funded by the central government and different voluntary organizations, and local bodies were entrusted with the work of implementing the scheme. Now, para 3, your lordship. Between the year 1976 to 1989, the director of AIMS appointed respondent number 1 to 6 on various posts to carry out the work pertaining to the ICDS entrusted to AIMS by the central government. Significant is to note that the terms and conditions contained in the appointment letter issued by AIMS to respondent number 1 to 6 clearly stated that the post against which they were appointed was purely temporary and was likely to continue till ICDS schemes lasted. Now, these people were discontinued. Your lordship will come to para 7. Has your lordship got it? In view of the retirement of Dr. B.N. Tendon, who was in charge of ICDCS project run by AIMS, it was decided to discontinue the said project. However, the Central Technical Committee, which was constituted to monitor the progress of the ICDS project run by AIMS, was not disbanded. And it was decided that the said committee, which will henceforth be known as the Central Technical Committee, Integrated Child Development, shall continue to carry on the said project. It was further decided that the Department of Women and Child Development, Ministry of Welfare, Government of India shall provide funds to CTC for carrying on the said project. Now, para 12. The case of the respondent number 1 to 6 is that they are the employees of All India Institute of Medical Science, having been appointed on various dates between 1976 to 1989 and have worked for various periods ranging between 11 to 15 years as temporary employees. Now, your lordship will come to para 16. Your lordship will skip the fifth line, according to the learned counsel.
Yeah,
Yes,
the council for the go through it.
yes.
Fix it in the next time also over.
Your lordship, the crux of the judgment is that it says that an agency which provide the funds to the any agencies cannot be made arrayed as a party respondent. Otherwise, it's a blot to us, your lordship.
Yep. But the Kadir
Hello, I am for respondent forest department.
Sir?
Forest department.
your name,
I bought it.
I read the code of ethics, for this that is India versus Rafael another like that content that the applicant not a third part or a proper part that a copy of the content the content for the entity white and let's subject the method for further on
10th, your lordship.
that
10th.
15
My lord, I have a humble prayer, my lord. Let the matter may be picked as a part hard because if it is come in the later part, it will not be possible to take. Part hard maybe.
Your lordship has not heard it. I'm not on merit, your lordship. The only part is that whether I'm a necessary party or a proper party or not at all. So your lordship has not entered the merit. My only contention is that I should be. Yes, your lordship. That part may not be added. Let it be before any other bench.
Why my lord, part hard may be taken up. What my difficulty of my friend, I do not know, my lord. If it is disposed of in the earlier, he will be. Part hard, he is objecting in listing part hard.
It has not been heard.
What is the difficulty, my lord? Yes.
Deeply apologize, your lordship.
Maybe the lordship. So in this case, I'm unable to contact the petitioner for that's one year. With a liberty to file a case, close it, lord. Because whether the scheme is whether the scheme is running or not, as on the that instruction also not with me, lord. Because it is a 1 year scheme, lordship. It was extended time to time.
part that they I was
For 1 year salary up to the petitioner, lordship. For the month of March 2023. As per the PDB lordship, they stated that the for the financial year 2023 to 24, the scheme will be operated loss.
heard the code of it part the global subject So it basically for him, made contact with petitioner. That's all. How about with the party? If
Lordship, regarding 52 paragraph matter, next week, if possible, Thursday. Yes. Lordship, regarding item 50, Your Lordship, in this matter, service complete, Your Lordship, kindly, matter may be fixed on admission. Respondent, private response have already appeared, Your. And affidavit has also been exchanged, Your Lordship. 50.
pardon, sir,
Mira, Your Lordship, for respondent number 6, Your.
I am for the respondent number 5.
sir,
Abstract Mojumdar.
how about
No, my lord, I would not trouble your lordship over a different matter. Same issue, my lord, services completed.
so who is for the petitioner?
I'm not for the petition matter, I'm for different item.
It's the matter after. After the
For admission.
Okay. Date may be fixed. Matter.
Actually, Your Lordship, in this matter, petitioner, although he has not applied for the post, but he has challenged my selection, my appointment, Your Lord.
after vacation, take it for
If I may take a date from my, I'm grateful, man. I'm grateful.